Good morning. We are going to get started. So welcome everybody. My name is Dana Sparks and I am the director of the Georgia Real Estate Academy, which is the entity offering this course for CE credit. And this course is the 2020 GAR, or Georgia Association of Realtors, Contracts Dissection course. This is GREC course number 71209. This is the first time actually this year that we have offered this course for CE credit. This is a virtual remote broadcast of an approved in-class course for 3 hours in duration. It has been approved by the Georgia Real Estate Commission for 3 hours of CE. I am also the instructor as well as the director of the school. This course does not require any homework or written exam. You must be on time and present for the entire remote virtual broadcast and instruction in order to receive CE credit. No recruitment, no telling everybody how fabulous your broker is. And we all hope you should all be in a brokerage where you believe your broker is fantastic. Please, at the bottom, this is the contact information for the school. Heidi Kelly is the coordinator of the school, and she is the one that will actually record the CE credits after class. For these virtual broadcasts, there are a series of 4 different reports that we get from this software to put them together for a CE roster, the chat transcription being one of them. So it does take us just a tad more time to record the credits. So it takes 3 to 5 business days to actually record the credits for this class. We do not send out anything letting you know they have been recorded. You will simply go to your own login on GREC, or your own broker can also see what CE classes you have taken. So I really love teaching this class, and we're really fortunate that GAR, they release new contracts in January of every year, as well as a mid-year review around May or June. Well, we're really fortunate in that GAR just released their mid-year revisions May 1st. So you guys are the first ones to see, unless you've already done a contract, to see some of those revisions that I will present in this class. I am also the qualifying broker of Maximum One Greater Atlanta Realtors. And so I just give you that context to let you know that I see contracts all the time. Now, I don't see every contract. We have 2 compliance brokers that see every contract, so I don't see those. I just see the ones that have issues. So, you know, I see like maybe 2 a year, right? Wouldn't that be wonderful? But I just wanted to give you guys a little bit of context that I am keenly involved with the contracts on an ongoing daily basis. Also, there are handouts available. You do not need them for the presentation of this class, but they are available for you as a reference after the class. And you'll see the handout of the GAR contract forms themselves with all of my notes underlined. There's also a handout of all of these PowerPoint slides. So write down this website, eagentweb.com. And then once you're there, you'll click on training videos and you'll scroll through to find the class and you'll get the handouts. All right, everybody, here we go. Again, if you have questions, everybody is muted. If you, for whatever reason, find yourself unmuted, please find the icon of the microphone and click it to mute yourself. We are so fortunate that we have Ming Richardson, CEO and founder of Maximum One Partners, who is helping me with the questions in the chat. So make sure you type your questions and make sure the message goes out to everyone. All right. Ready to rock and roll? Here we go. So generally speaking, GAR's intent is to keep all of the transactions together. Any changes they've made, they've done it for consistency among the forms, and any changes that they make every year are based on the market and real estate agents' practices, as well as any lawsuits that have come up and decisions by judges that have facilitated or prompted a change in the contracts. Again, the mid-year review was already done May 1st. Those have been released, and I will point those out. Not a whole lot of changes this year, but some really, really good ones. To use the GAR form, they are licensed and copyrighted, so you have to pay GAR, Georgia Association of Realtors, for that licensing agreement. You either do that by paying realtor dues to a board, or you can pay GAR directly. Also, you are never to give out the GAR forms just to the public. They're just for agent use. There is a GAR legal helpline. You must be a realtor with your NRDS number to access that, and the link for that is in GAR's website. All right, I always start off with any contracts class with some general contracts reminders. And I know we have some very experienced agents on this class, because we've got some low real estate numbers, and we have some brand new agents on this class, and we've got some agents that are coming back into real estate. So welcome back, and these contract reminders are for everyone. A legal description is always required. You guys, we have a street address alone is not sufficient. Just think about it. In Metro Atlanta, how many Peachtree roads are there? Right? More than one. Therefore, there's more than 123 Peachtree Road. So you definitely need a legal description on all your contracts to make sure that the property that gets conveyed is the property that is intended between the buyer and the seller. Also, per license law, make sure your public people get a copy of everything they sign. Also, your brokers will appreciate if you make sure they get a copy of that, and your lenders and closing attorneys will appreciate that as well. Any blanks, you will want to put in either NA for not applicable, or NC, which would stand for no change. So especially on the counter offer, you're going to put in NC as opposed to not applicable. So for example, let's say a buyer makes an offer and the sale price is $250,000, and asking for closing costs, closing date, so forth and so on. And let's say the seller makes a counter offer on the counter offer form. They're fine with the price, but they want to counter the closing costs or date or something like that. Well, you're not going to put NA in the price, because of course the price is applicable. So you would just put NC on that counteroffer form for no change from the original offer. Also, you don't want to use TBD for to be determined. You definitely need to fill in all the blanks with whatever dates or terms are required. And if the fill in the blank has a dollar sign, you're going to put in $0, not NA. All right. Also, it is required by license law that you put in your license number and your firm's license number on the contracts. For the GAR form, there's fill in the blanks for that. But just remember, if you are ever part of a contract that's a HUD contract or a new construction contract, if they don't have fill in the blanks for that, you need to add those items in, your license number and your firm's license number. Also, per license law, you must complete the agency representation disclosures in the contract. Again, there are fill in the blanks for that on the GAR forms, but new construction, HUD, so forth and so on may not have that. So you must indicate that you do have an agency relationship with the public. Follow up on the earnest money deposit. I don't care who the holder is, if it's your broker, the co-op broker, a closing attorney, it is your responsibility, both as the selling agent and the listing agent. You need to follow up. Did you get the earnest money? Did you deposit the earnest money? Did you get the earnest money? Did you deposit the earnest money? That's important for both the buyer and a seller. That's why it is incumbent upon both sides, the agents on both sides, to follow up. And all buyer and seller signatures are required. What I mean by that is if you have a couple or an estate or several, just more than one person who is going to go on title all of those parties need to sign the contract. You can't have, for example, if you have a couple, you can't have just one of the parties of the couple sign the contracts. We need both of that. And for customers, you need contact information. I'll get more into that when we talk about the notices section. All right, you guys, I know for some reason y'all love writing special stipulations, but please stop. Y'all end up unintentionally writing special stipulations that do not have the intention, that end up in essence not protecting your client like your intention is to protect the client. Please, if you feel like you want to write a special stipulation, check with the GAR library. They've got a gazillion special stipulations already pre-printed. And there's also fabulous special stips in the RE Forms contract package as well. Check with your broker or an attorney before just writing them on your own. Also, just generally speaking, in the GAR library, there are a ton of other useful forms. All right, just generally speaking for 2020, there are a few new forms. We're not going to cover this. We cover this in that other CE class we teach on the GAR contract changes. But I just wanted to point out to you that for new construction, there's a change order amendment, and there are 2 new short forms for leases as well as a pool on the lease. Also, there are 2 new special stips. We will cover those today when we get to the loan financing contingency exhibits. All right, ready to get started? Here we go. So this form that I'm talking about is the purchase and sale agreement. It's GAR form F201, and you need a legal. You guys, this class. Let me back up a little bit by saying I'm not going. This is not a line by line fill in the blank class. This class is going through the entire GAR purchase and sale agreement, the financing contingency exhibits, as well as some of the other often used exhibits. But we're just going to talk about the concepts and conceptually what you need to understand, what your responsibilities are as an agent, as well as what the buyer and the seller are agreeing to with respect to this contract. So it's not a line by line fill in the blank class. If you have questions about that, I will stay on during the break and after class, but we're going to just cover conceptual issues. So legal description is required in addition to an address. In the GAR contract, the holder of the earnest money, you're going to fill in either one of the brokers or a closing attorney. If you do write in that there is a closing attorney who is going to be the holder of the earnest money, you absolutely must attach this GAR form F510, which is an exhibit, and to be with the contract. And then after your binding, the closing attorney must sign this form F511, which is an agreement. I'll discuss these forms a little more in depth when we get to them later in the class. But I just wanted to point out that if you name a closing attorney as the holder, you absolutely need this exhibit F510. Additionally, on that form, you must name an alternate holder, which is either the listing broker or the selling broker. Again, we'll cover that a little bit more. Now, the form of the earnest money. If it is a check, that means a personal check or a certified check. Cash also means a money order. You guys, do not deal with cash. Do not deal with actual paper money. If you're going to deal with cash, it must be a money order. You cannot track cash, and you just don't want to put yourself in a bad position where it turns into a discrepancy between what the public says and what you say regarding if you received cash or not as earnest money. Or it can be in the form of a wire. Now, one thing to note, and I talk about this at the end of the class, I have a lot of points of practice regarding earnest money. Just keep in mind that many brokers have a time frame under which they must hold personal checks. So point of practice, it's probably best to deal with certified funds. Now, the time frame to remit the earnest money. You guys know in the purchase and sale agreement, there is a section where the buyer and the seller negotiate. Buyer either has already put in earnest money at the time of the offer, or it says buyer to remit earnest money to the holder within X number of days from binding agreement date. Just one thing about the earnest money, if it is in the form of a wire, there is a lot of wire fraud and cyber fraud in our industry. So general practice for brokers as well as closing attorneys is to not email wire instructions. Either the wire instructions are delivered to the buyer or to any of the public by U.S. mail, overnight delivery service, or courier service, or hand delivery. But if you have to send the wire instructions to the buyer by U.S. mail, you need to consider, don't put in the buyer will remit earnest money by wire to the holder within 3 days. It's going to take more than that for them to even receive the wire instructions. So just keep that time frame in mind if you know that the earnest money will be in the form of a wire. All right, under brokerage relationships, again, this is required by law. Now, so this is where you would fill in. This is the purchase and sale agreement. This is the bottom of the front page where it says broker relationships in this transaction. You're going to fill in selling broker is ABC Realty and is representing buyer as a client, customer, dual agency, or designated agency. And on this side, it says listing broker is XYZ Realty and is representing seller as a client, customer, dual agency, or designated agency. Let me back up. So in order to create this client relationship with the buyer, that means the buyer has signed the buyer brokerage agreement. In order to sign a, work with a buyer as a customer, they have signed a customer acknowledgement. On the seller side, in order to work with a seller as a client, that means they have either signed the exclusive listing agreement or the non-exclusive listing agreement. So the non-exclusive listing agreement also creates the client relationship between the public seller and the broker. It's just that a non-exclusive listing agreement allows the public seller to create a client relationship with this broker, that broker, another broker, any broker that they choose, and the first broker that brings them a contract, in essence, gets paid. To work with a seller as a customer, that would mean the seller has signed the authorization to show unlisted property. Now, for both of these, dual agency, it is not illegal. It is legal if there is disclosure about it and written consent by the buyer and the seller. However, your broker may have a policy for or against allowing you to enter into a dual agency relationship. So you need to check with your broker. But in essence, dual agency means one broker, one agent, and that agent has a client relationship with both the buyer and the seller. Designated agency, that means there's one broker, two agents, and one agent has a client relationship with the seller, the other agent has a client relationship with the buyer. And in that situation, you put in the name of the actual agent who is working with the seller or the buyer. Now, you can have both sides of a transaction without it being a dual agency relationship. And in that situation, the broker would have a client relationship with either the buyer or the seller, and then they would have a customer relationship with the other party. Additionally, you could have a customer relationship with both of the parties. And again, you would have both sides of the deal without it being a dual agency relationship. Again, please check with your broker on if their brokerage policy will allow that. Now, also at the bottom of the of every page of the GAR contract, but on the bottom of page 1, it says page 1 of 8. Since this document, the purchase and sale agreement, references more than one page, you must include all pages when sending it to a co-op agent, to a buyer, to a seller, to your broker, to the closing attorney, or to the lender. You cannot simply send just a signature page. Because it indicates there's more than one page, the document must be complete when sending it to any of the parties. All right. Now, in the purchase and sale agreement under paragraph B1, this is where it talks about the title that is being conveyed by the seller to the buyer. Now, it must be good and marketable title, and the type of title is limited warranty deed. So, you guys, it's really different teaching a class by Zoom without versus being in person, where I get to ask you guys questions and let y'all answer. So when I ask questions, just think to yourself, or you can type it in the chat box. But limited, good and marketable title, basically down here is defined. It doesn't mean that the title is insurable, which is what the public thinks. It has everything to do with money. For example, it's insurance, right? So when you go to get car insurance, you can get a different premium rate based on a couple things, either based on the insurance company from which you shop, or the insurance companies for auto insurance, for example, they have all different types of risk tolerance for the driver. For example, a male driver under the age of 26, if any of y'all have insurance for those that category, you know their insurance rates are for the premiums are way more expensive than an insurance rate for an adult over the age of 26 or a female over the age of 26, because they have different risk tolerance rates based on the risk of the driver. So for title insurance, there are different rates for the premium based on a couple things. One is the bank account or the solvency of that title insurance company. And the other thing is the title search, the risk level of that property itself. For example, have there been gaps in title? Are there power lines or gas lines running close to the house? So good and marketable title just means that the buyer can get title insurance and the premium is regular rates subject only to standard exception. So there are properties that can be insured, but you may have to pay a higher rate. And in that situation, it's not necessarily good and marketable title. The parties would have to amend the contract. Now, also, the limited warranty deed means that the seller warrants the title just during the time of their ownership. Now, one thing to notice is the buyer has the right in this contract to examine the title, and if there is an objection to the title, and usually the buyer, him or herself, does not actually examine the title, but you're going to get information from the closing attorney that there's a title issue. For example, there's a gap in the title, or something wasn't recorded properly, or there's a lien on the title, or something like that. So in that instance, the buyer must give the seller a notice that there is an objection to the title, and then the seller has the time frame to cure. They have the time frame up through closing or any unilateral extension, as long as that objection does prevent the seller from conveying good and marketable title. And then if the seller does not cure, then the buyer may terminate the agreement. So you guys will notice that anytime there are termination rights addressed in the GAR contract, these elements are there. First, there must be notice of the default given. Then there is a time frame to cure the default. And then there are termination rights after that time frame. And typically those termination rights are limited by their own time frame as well. But I just wanted to let you know, now in this situation for termination rights by the buyer simply cannot not show up to closing. The buyer, if they were going to exercise their termination rights based on an objection to title, they would have to do so after the seller has had a time frame to cure and doesn't cure. They must send notice of termination prior to the closing date on the contract. If a party just does not show up to closing, that is a default. That is not a termination. All right, closing date and possession. So regarding the right to extend the closing, the GAR contract has in here that there is a right to extend the contract for 8 days unilaterally. What does unilaterally mean? That means that you only require one party's signature. So unilateral means you only need either the buyer or the seller's signature to extend the closing. So that means the other party is held into contract against their will. Why do I say against their will? Well, if they had agreed to an extension, then the parties would have extended the contract by amendment, where you get both parties' signatures, not unilaterally. So in order to use this unilateral right to extend the closing, there are only certain very specific reasons that a buyer or a seller can extend it without the other's agreement. The first issue is if there is a title objection, as long as that title objection can't be satisfied with money. So for example, if there's a lien on the title, that could be satisfied by paying money. Therefore, you cannot use the unilateral extension to extend a contract for 8 days if there's a lien. The seller needs to take care of that prior to closing, or the parties need to extend it by an amendment. And if the title objection does not prevent good and marketable title conveyance. The other reason that the parties can use this 8-day unilateral extension is based on lender issues. Well, either lender or attorney, if either of them cannot complete their responsibilities. For example, the closing attorney cannot get it scheduled, and we are seeing a lot of those issues with some of the issues we're experiencing now with social distancing and issues like that. Sometimes closing attorneys cannot close on the scheduled closing date. So that would be an issue if they have not completed the title work or can't close, or if the lender has not completed their responsibilities prior to the closing date. Further lender issues is if they cannot fulfill their obligations by closing, as long as that delay is not caused by the buyer. Now, are you going to find out if that delay is caused by the buyer? That's another question. But the other issue is if there is a lender delay and the lender cannot fulfill their obligations by closing, if the buyer has not received what we lovingly refer to as the TRID disclosures. That stands for Truth in Lending RESPA Integrated Disclosure Statement. And basically the lender has to send out a certain fee sheet on fees that cannot change to the buyer within 3 days prior to closing, or there is a federal regulation that prevents them from closing. Now, the 8-day unilateral right to extend the contract may only be used one time per contract, not one time per side, but one time per contract. And either party may use it for any of the reasons. So let's say you have a seller and the seller learns that the lender is delayed. The seller may exercise the 8-day right to unilaterally extend for a loan issue. So that's what I mean is either party may use for any of those reasons. Now, here's a little something that a lot of people don't consider. When is 8 days not really 8 days? So for those of you at home that are working with your stay-at-home children doing math, this sounds like a math problem, but this is a real estate agent contract problem for GAR. So this only happens when the original or any amended closing date is on a Friday. So let's look at this. 8 days from Friday is what day of the week? Well, it's a Saturday. You can't close, and the purchase and sale agreement in paragraph C4F states extension of deadlines. No time deadline under this contract shall be extended by virtue of it falling on a Saturday, Sunday, or federal holiday, except for the date of closing. What does that mean? That means that, for example, if your due diligence period or whatever contingency, if the last day of that falls on a Saturday, then it falls on a Saturday. If the last day of whatever contingency falls on a Sunday or a federal holiday, that is the last day of that contingency. However, the closing date does not abide by this. So the closing date automatically extends to the next business day. Therefore, 8 days from a Friday, we can't close on a Saturday, and it's a closing date, so it's automatically extended. So if 8 days from a Friday would end up being the closing on a Monday, and if Monday is a federal holiday, then we go to the next business day, which is a Tuesday. So when is 8 days not really 8 days? Well, if your original closing date is on a Friday, then 8 days magically becomes 10 days or potentially 11 days. So, point of practice, if you guys go binding on a GAR contract form, when you are negotiating for the date of closing, pull out your calendar and don't close on a Friday. Close on a Wednesday, close on a Thursday. Actually, your closing attorneys and your lenders will probably appreciate that because it's not quite as busy. But per the contract and the 8-day unilateral extension, combined with this paragraph extension of deadlines, if you close on any other day. So if our original closing date's on a Thursday, 8 days from Thursday is a Friday. So this only happens when your original or amended closing date is on a Friday. All right, moving along to the remittance and deposit of earnest money. Again, we are in the purchase and sale contract, and this is under paragraph B5. So you'll see up here that references the actual paragraph. So the remittance time frame, that's negotiated by the buyer and the seller. As I talked about at the beginning, buyer to remit earnest money to holder X number of days from binding agreement date. That time frame is, you work that out in your negotiations. But, and again, as I mentioned, add in additional time if you know the earnest money is going to be a wire. But the holder must deposit those funds within 5 banking days. So that is pre-printed in here when the holder must make the deposit. Also, it states in here that the holder also has to have a time frame that to hold the money. So again, if it is a personal check, that typically takes a longer to clear the bank than certified funds or a money order or a wire. So make sure you need to check with whomever is holding the earnest money, whether it be your broker, the co-op broker, or the closing attorney, if they have a policy on holding personal checks. And again, I'm going to cover that a little bit more at the end under earnest money. Because the contract states that the holder does not have to act on that earnest money until it has cleared the bank. So I got a question about, is this class being recorded? I do have it recorded. I am recording it. And we just hope that the software records the whole thing. But it should be recorded, and the recording will also be at that same place where you can download the handouts, www.eagentweb.com, and you click on training videos. I'll give that information out again, but the video recording, once it is recorded and posted, as well as the handouts, will be in that location. All right, now let's look back at this. Now, what does this say? What happens if the buyer never sends in the earnest money? Or what happens if the buyer does write a personal check for the earnest money and it bounces from the bank? That never happens, right? All right, I'm gonna let that dead space lie right there. So if the earnest money never gets to the holder, so either the buyer has never sent it in, or it bounces from the bank, in which case the holder is not in possession of those funds, the holder must give notice to the buyer and the seller. So the rest of this contract talks about that. So for example, you guys think about it. This purchase and sale agreement, in essence, is a receipt for thousands and thousands of dollars being held by whomever is named holder. If the holder never got it or doesn't have it in their account because the bank didn't honor it, then the holder better give notice that, look, this receipt is no good. I do not have those funds. So if it's not received or if it is non-sufficient funds, the holder sends notice of the default. This would be a buyer default, and they send notice to the buyer and the seller. Here we go again with default, right? We have notice. The buyer has 3 banking days to cure the default. In other words, make good on the earnest money. If no cure, the seller has 7 days to terminate. If the seller does not terminate within 7 days, so you've got notice being sent, 3 banking days. If no cure within those 3 banking days, the seller thereafter has 7 days to terminate. If they don't terminate, the contract continues. There's just no earnest money in the deal. Earnest money is not required for a binding contract. So if there's no earnest money in the deal based on this situation, you guys, you need to make sure the lender knows and the closing attorney knows so that the settlement statement reflects there's no earnest money in the deal. So what has to happen? It just means there's no earnest money on hold. Kind of like layaway. Earnest money is like layaway. The buyer puts in a little money, good faith money up front, and they bring the balance of what they owe at closing. So if there's no earnest money in the deal, then at closing, they just have to bring the total funds. They don't have any money already on deposit. All right, now let's talk about the closing attorney. The GAR contract states that the buyer has the right to select the closing attorney. However, if there is a mortgage lender, the closing attorney represents whom? They represent the actual lender. Now, if there's not a mortgage, then the closing attorney, this states the closing attorney shall represent the buyer. You guys, be careful. Your public people think that has a completely different meaning. This verbiage shall represent the buyer. That only means the closing attorney represents the buyer with respect to the buyer's position in the contract. It does not mean that the buyer has legal representation if there's a dispute. I don't know of any attorney that works for free if they have to represent a public person in a dispute. All this means, so if there's a loan and the attorney represents the mortgage lender, the mortgage lender sends what we call the package to the closing attorney. Well, what's that package? That package is merely a set of instructions to the closing attorney how to prepare the closing documents, right? So if there's no mortgage lender involved, the poor closing attorneys, they don't get instructions. What are they going to do? Well, the contract tells them what to do. The contract tells the closing attorney that if you're not getting these set of instructions from the mortgage lender, then you prepare all the closing documents with respect to the buyer's position in the contract. Now, you guys don't get too confused. The closing attorney, the GAR contracts clearly state what has to happen for a buyer and a seller, and your closing attorneys know how to prepare the closing documents. This is more just legalese indicating instructions to the attorney with respect to the documentation. Generally speaking, your purchase and sale agreement is nothing more than a set of instructions. That's all it is to everybody. You guys, your purchase and sale agreement and all the exhibits and the amendments, it's instructions to the buyer. What does the buyer have to do in order to get title to this property on a date in the future? Well, they have to bring X amount of dollars. They have to do this. They have to do that. What does the seller have to do? Well, at a certain date in the future, i.e. the closing date, the seller has to be able to convey good and marketable title that's unencumbered. What does the closing attorney do? Well, the closing attorney prepares the closing documents with respect to the instructions. What does the lender do? Well, the lender gets a buyer a loan. So what do you guys do as agents? Everything this contract is just a set of instructions. So whenever you have a question as a contract is playing out, the first thing to do is go back and find that section in the contract and see if you can find the instructions, what it tells you to do. Most of the time, you'll find your own answer in the purchase and sale agreement itself. All right, now let's talk about disbursement of earnest money. In a purchase and sale agreement, when a buyer puts in earnest money, it is potentially up for grabs if there is an issue. Nothing is an issue unless it's an issue. But when it's an issue, we have to go back and see what happens. So if there's no issues, then the holder can disperse the earnest money back to the buyer. If the buyer never goes under contract, a lot of times, and for those of you who have been practicing for over 20 years, you guys will remember that when you first met with a buyer, the buyer used to write a check to your brokerage for earnest money, and the brokerage would deposit those funds on behalf of the buyer before we ever got a property address or contract to go with that. So if the buyer never goes under contract, then the holder can disperse the earnest money back to the buyer. If the property closes with no issues, then the earnest money gets credited towards the buyer at closing. Also, if there is a written agreement signed by the buyer and the seller directing the holder how to disperse those funds. Well, what's that? Yep, you got it. That's what we lovingly refer to as a T&R. T&R stands for termination and release. That is GAR Form F522, which is the unilateral notice to terminate and proposed agreement to disperse earnest money. I'm going to cover this form a little more in depth towards the end of class. But again, we already discussed this. What does this word mean? Unilateral. One signature. It only takes one party's signature to terminate a contract. Once it's terminated, it is terminated. Where you need both signatures, agreement indicates both two parties. You need two parties to agree. So you need both signatures on the release portion of the T&R, but you only need one signature to terminate. In fact, notice, whenever you see the word notice, all notices are unilateral. So you only need one party's signature whenever a party is giving notice to the other party. But anytime you see the word agreement, you need both party signatures. Now, the parties may agree to divvy up those funds any way they want. Typically, we see 100% of the earnest money on hold going either to the buyer or to the seller. But there's nothing to prevent a buyer and a seller for negotiating how to divide up those funds. Well, I'll give the buyer half back and the seller keeps half, or 70% to one party, 30%. So this might be something to keep in mind, especially right now. We are in the climate, we are in the spring of 2020, and we are experiencing an unusual situation of a global pandemic due to the COVID-19 virus. And this is wreaking havoc in the world. And with respect to the real estate contracts, we have some buyers that are fully approved and qualified and ready to go on a loan. And then all of a sudden, because Fannie Mae, Freddie Mac, FHA, VA are changing the way they do business suddenly by increasing interest rates or increasing debt to income ratio or things like that, all of a sudden a fully approved buyer is finding him or herself not approved and not able to get the loan, but they are outside of their financing contingency. So contractually speaking, if they're not able to close, that buyer would default on the contract. But there is nothing to prevent a buyer and a seller from directing the holder of the earnest money to disperse those trust funds any way they negotiate. So we are seeing a lot of contracts right now in the spring of 2020 where that is happening, and the seller is actually giving the buyer a portion of the earnest money back, if not all of it. But generally speaking, even outside of any global pandemics, this is always an option for the parties. Now, what happens if there's issues. I hope none of y'all ever have any issues where a contract terminates, but you don't get both parties' signatures agreeing to release the earnest money. Okay, I got a question about, okay, let me go back a minute. So what happens, as I said, a notice to terminate is unilateral. So you don't need both parties agreeing to a termination. Once a party terminates, they terminate. The question is, what happens if a party terminates and then they later change their mind and want to go through with the deal? Well, guess what? This deal is dead. You need a brand new contract. So you will have to address the earnest money for this terminated contract and write a brand new contract. Okay, what if there are issues? Again, contract terminates, but both parties don't sign the release portion. You only need both party signatures on this portion. Well, the holder has a lot of things available to them in order to figure out what to do with the earnest money on hold. One is they can do a reasonable interpretation of the contract by what we call the 10-day letter. The holder sends notice to both parties of their intent to disperse the funds based on the holder's interpretation of what happened. What did the parties agree to? Why did it fail to close? Did it not close because one party defaulted on the contract? Or did one party terminate and based on a contingency and it had not expired? Did the other party not sign the release portion because they didn't agree? Did the other party not sign the release portion because they are angry? So there's all kinds of things that the holder does to figure out what happened. We not only look at the contract, but we go back to you guys as agents and say, okay, if the buyer, for example, terminated under due diligence and you had a 12-day due diligence period, show me the email where the buyer actually sent the notice of termination to the seller. Did the buyer send that termination within those 12 days? Is the seller not signing it because they're upset? Is the seller not signing it because the listing agent can't get a hold of the seller or whatever reason? So sometimes there are terminations within contingencies. Sometimes there are terminations by default. It's called the 10-day letter because the holder, after they send notice of what they're going to do with the earnest money, the holder has to wait 10 days from the date of that notice in order for the party not getting the money to object to the holder's decision. The important thing is these funds are tied up during this time and cannot be used for another contract. They may only be dispersed after that 10-day time frame. So here's the issue. What happens if you're working with a buyer and let's say the buyer does terminate this contract before the expiration of the due diligence period and the buyer goes and writes an offer on another house? Well, what's seller number 2 going to want? They're going to want earnest money also. If we don't have both party signatures on the TNR releasing the earnest money back to the buyer, this money is tied up. Seller number 2 is going to require additional earnest money. You have to talk to your buyer about putting in additional funds. That's an issue that you are going to need to address, and I'll talk a little bit more about this in depth at the end of class. Now, the holder, also an option that the holder, if there's a dispute over the disbursement of the earnest money, is they can file what's called an interpleader action. And this is available to holders if there's too much money or it's too complicated of an issue. And by complicated, I mean legally complicated. There are valid legal reasons on both sides of the transaction regarding termination and rights to the money. Now, no attorneys work for free, so the holder has to hire an attorney to interplead it and let a judge decide. So we have to hire an attorney, and there are court costs to file these actions. So guess where that money comes out of? Yep, comes out of the earnest money. So the loser, so once it goes to court, a judge decides. The holder, I get to deduct my fees from the earnest money on hold, and the loser has to pay the winner's legal fees. So it could be really, really expensive as well as time consuming. So it depends on the county. It depends on the attorney's fees. It depends on the time for this legal action to actually take place and any notices sent. It can get really expensive. So if your earnest money is less than $5,000 and you get information from the holder that they're going to interplead the funds, it might behoove the buyer and the seller to negotiate for the disbursement of those funds between themselves rather than go to court, because one of them's going to have to end up paying more if the fees exceed the amount of earnest money. Now, the holder of the earnest money may also disperse the funds based on a court order. So if we get a court order signed by a judge telling us what to do, that's what we do. Now also, and all of this is all outlined in paragraph B7 of the purchase and sale agreement. There is also a hold harmless agreement that the parties, the public buyer and seller, may not sue the holder for their decision. All right. We're going to, again, as I continually mention, I'm going to talk about you as an agent and your the important things about earnest money and the discussions you need to have with your buyers and your sellers, and the things you need to know as being per license law with the handling of earnest money towards the end of class, because it's very important, and there are a lot of license laws around your interaction with earnest money as well. Okay, moving along. Let's talk about, I got to talk a little faster. All right, let's talk about due diligence. The due diligence period in a contract, and this is all outlined in paragraph B8, states that it is merely a buyer's option to terminate the contract with no penalty. That means they get to keep their earnest money for any or no reason. That's all due diligence is, you guys. It is just an option to terminate for any or no reason and keep the earnest money. The buyer, however, must send that termination notice prior to the expiration of the due diligence period. So you agents working with buyers, that doesn't mean you just get it signed before the expiration of the due diligence period. That means you get it signed and sent to the seller before the expiration of that time frame. Now, generally speaking, a seller must disclose latent material defects in the property. Those have to be defects in the property, and latent material defects are defined as those defects of which the seller is aware and that could not have been discovered by the buyer by reasonable inspection. This Georgia law, where a seller must disclose latent material defects, is very, very difficult to prove in a court of law. What do I mean by that? Well, first of all, you have to prove the seller was aware. Secondly, it has to be a defect in the property that a buyer can have discovered. So, for example, there are a lot of things like leaks and things like that, or survey issues that a buyer could have discovered with reasonable inspection. That does not meet the terms of it being a latent material defect. The other part of that is you have to be able to prove the seller was aware of that. Georgia is a caveat emptor state. What does that mean? What does caveat emptor mean? It means the actual interpretation of the Latin is buyer beware. That means that the burden is on the buyer to make sure that the buyer is completely satisfied with what it is they are purchasing prior to exchanging money for goods or services. So this due diligence period gives the buyer this no penalty time frame to make sure that they're satisfied with what it is they're buying before having to go to closing. So a buyer may do all kinds of things to help that buyer make the decision to proceed or terminate. So all kinds of inspections. They can have a home inspection, roof inspection, foundation inspection, survey, check out the distance to work, check out, make sure it's in the proper school district they believe it is, check out the zoning, any potential zoning changes that are scheduled to be voted upon, check out the neighborhood, check out the area, how close is it to the grocery store, how close is it to the movie theater, all kinds of things. It is a home inspection is not required. A home inspection does not have to be done by a certified home inspector. These are things that a buyer does to help them make their decision. Should I stay or should I go? Dun, 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 dun. These are things a buyer may do to help them make the decision to stay in the contract or terminate. Now, based on these things, a buyer can say, hey, you know what? I'm still trying to decide if I'm going to stay in the deal or terminate. So, Mr. and Mrs. Seller, I have some concerns that I want to see if you will address or not. There is a form, the GAR Form 704, which is Amendment to Address Concerns with the Property, where the buyer asks the seller to go through, will you do this or will you don't do this? Again, I'm going to talk about this form a little bit more in depth later on in the class. The buyer and the seller must agree to these prior to the end of due diligence. If you do not get a buyer and a seller signatures on this form before the end of the due diligence period, and the buyer does not terminate, then the buyer is buying the property as is. So as is doesn't mean that there are no faults. As is simply means the seller will not address any issues. If those issues are something the buyer is not comfortable with, then the buyer needs to terminate before the end of due diligence period. A buyer's signature on an amendment to address concerns that is not signed by the seller does not mean anything if you go past the due diligence period. A due diligence period may only be extended by agreement, and there is a GAR Form F710 that is amendment to extend the due diligence period. It's not a unilateral extension. The buyer and seller must agree to any extension. So let's think about this. How do you selling agents protect a buyer's due diligence time frame? For example, let's say the utilities aren't on. Let's say the seller hasn't provided you with the community association disclosure to disclose the fees. Well, what happens? Your buyer's due diligence time frame starts ticking from the time you go binding. And, you know, a buyer wants the house. They don't necessarily want to terminate, but they can't get it inspected if the utilities aren't on. So what is it that you do? Well, you need to add a special stipulation. So a lot of people, when I ask this question in class, is sometimes you'll write a special stipulation that says due diligence period to begin upon seller turning on utilities. No, 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 no. You guys do not do that. If you don't start the due diligence period until this issue has been corrected, the buyer could never terminate if the seller never corrects it, because due diligence would not have even started. So what do? You're going to write a special stipulation that says due diligence to begin upon binding agreement date, and then extend for 10 days or whatever number after the buyer's receipt of written notice of whatever. So for example, let's say the seller has not turned on the utilities. You would write due diligence period to begin upon binding agreement date and extend for 10 days after the buyer's written receipt of notice of utilities being turned on and operational. So that means the buyer can terminate at any point with no penalty, or after they find out, let's say it takes 4 days for the seller to turn on the utilities and let the buyer know. Well, then you have an additional 10 days or whatever for the buyer, so they don't have to pay money for an inspection prior to that issue. So again, you want it to begin upon binding and then extend for however many number of days after this issue has been corrected. All right, now let's talk about the repairs. So let's say a buyer and a seller agree and sign the amendment to address concerns with the property. Well, what does the contract say about those repairs? Well, the contract states the only thing in the purchase and sale agreement, and this is in paragraph B8E, it states that the repairs must be done in a good and workmanlike manner and must be done prior to closing. That's all the contract states. So what if the seller agrees to perform repairs, in other words, signs the amendment to address concerns, but doesn't do them? What happens if you do a walkthrough and the repairs aren't done by the seller? May the buyer terminate? May the buyer close and sue the seller for contract breach? There is no clear answer. Again, there's no termination rights for the buyer in the contract with respect to repairs. And remember earlier I said every place else in the GAR contract where it talks about termination rights, there are 3 elements. Number 1, notice of default, time frame to cure, and then if no cure, a time frame for the other party to terminate without penalty. That is not addressed with respect to repairs. The only thing addressed is good and workmanlike manner prior to closing. I don't see anything about termination rights in there. Well, what about, can a buyer sue this, go ahead and close and sue the seller? Nope. Repair issues don't survive closing. So the buyer may not have grounds for suing the seller after closing. This is a very, very difficult issue and very difficult to address after it's an issue. So you guys have got to address this issue up front. There is no clear-cut answer if a buyer can terminate and not default, or if a buyer can sue the seller. There are 2 legally valid positions with respect to the contract, and it would be up to a judge. But I don't want you guys getting in a situation where we have to leave it in the hands of a judge. So what do? Well, you need to address the potential issue of the seller's non-performance when you are addressing the repair issues. So when you are writing on the amendment to address concerns with the property, when the buyer is asking the seller to repair or replace certain things, you want to use this magic phrase. Write this down. This provision shall survive closing. This magic phrase does give the buyer grounds to sue the seller after closing. And I'll talk a little bit more in depth in this when we talk about the survival clause in just a minute. Another option would be for the seller to pay a vendor at closing from the proceeds. Another option would be perhaps the seller escrows funds and takes care of the repairs, and there's money up for grabs if the seller does not take care of their repairs. But these options are not available if the buyer and the seller do not agree to them. So you must address these potential issues as in essence, a special stipulation on the amendment to address concerns. We have these all written out for you. Again, if you go to this website, eagentweb.com, and you click on training videos and you find this class, one of the documents available for you to download will say repair stipulations to consider. Whenever you are adding special stipulations, as I mentioned at the beginning, check with your broker or an attorney prior to using them in a contract. I will let you know that all of these special stipulations that I offer for you, they have been written by an attorney. Some of them are the GAR special stipulations, some of them are the RE forms special stipulations, and some of them are merely authored by an attorney. All right, moving along. Brokerage relationships in the purchase and sale agreement. This is outlined in paragraph B10. You must disclose the agency relationship. We talked about that at the beginning when we talked about client relationship, customer relationship, dual or designated. An agency relationship means you have a client relationship. Oh, here's where I thought I had it. The public is a client. If the seller becomes a client, if they sign the listing agreement, again, either exclusive or non-exclusive. But either one of those forms creates the client relationship between the public seller and your broker. To become for a public buyer to become a client, they sign either the exclusive or non-exclusive buyer brokerage agreement. The public is a customer, a seller is a customer if they sign authorization to show unlisted property, and the buyer would sign the agreement to work with buyer as a customer. And these are those form numbers. Again, you guys, these PowerPoint slides is also a handout available to you on that previous website. Again, I thought I had it. The agency relationships, dual agency, one broker, one agent, client relationship with both. Designated agency, one broker, two agents, each with a client relationship with the public. Having both sides, client relationship with buyer or seller, customer relationship with the other party. Not dual agency, but tricky, and check with your broker. Now, moving on to the consumer brochures. You guys, these are probably one of the least often used documents in the GAR contract packages that you should use. Y'all use whatever of these consumer brochures are applicable to your public person and be able to demonstrate that you get these into the hands of your buyers and your sellers. This will protect you if something becomes an issue, because you can say, look, I gave my public buyer everything that I had available to me regarding that they should test for radon. I gave my seller everything available to me regarding how they should protect themselves when selling a home, buying a home with an HOA, so forth and so on. You guys definitely need to go through these, and as a point of practice, use these in all of your contracts. Get these into the hands of your buyers when you're getting them to sign either a buyer brokerage agreement or a customer agreement. Get the appropriate ones into the hands of your sellers, whether working with the seller as a client or a customer. Now, moving on again with the brokerage relationships, paragraph B10. There is a whole lot to this section. And again, all of this is all spelled out in the contract. So are broker and agent signatures required? Well, the answer is no. So when you, as an agent, sign a contract, what does that mean? Well, here is where it is spelled out. Oops. I don't know how to get this smaller. Because that changes it. All right. Anyway, what it states in this paragraph is that your signature or your broker signature on a contract merely affirms the agency relationship that you indicated in paragraph A10, and it confirms that the holder will perform the contractual responsibilities outlined in the contract. So you are an affiliated licensee. With whom are you affiliated? Me, your broker. So when I agree to accept you onto my brokerage and sign an independent contractor agreement with you, I give you permission and authority to sign contracts in my name. So all contracts belong to the broker, whether it be a purchase and sale agreement, a buyer brokerage, a listing agreement, all contracts belong to the broker. So you as the client, as the agent, you're signing as an affiliated licensee with whom. So when you sign a purchase and sale agreement, again, it means that the broker has a client relationship with the buyer or the seller. And if me as the broker is designated as the holder of the earnest money, I give you authority to sign stating that I will perform those contractual responsibilities. Now, so your signatures are not required for enforceability of the purchase and sale agreement between the buyer and the seller. However, we had an issue a few months ago where we could never get, we represented the buyer, we could never get the listing agent nor the listing broker's signature on the contract. So here in the GAR contract, I'm telling you what your contract means, and for enforceability, it is not required. However, in practice, that buyer's lender required the agent or broker's signature because they couldn't sell the loan otherwise. So the buyer ended up having to terminate the contract because we could never get the the listing agent or broker signatures. And it was just the craziest thing. So is it a good idea to sign it? Yes. Is it required for enforceability? No. But in practice, there may be some extenuating circumstances. Now, further on in this paragraph B10C, this is the disclaimer paragraph. And as I've just said, nothing is an issue until it's an issue. When it becomes an issue, you are going to be awfully glad that this paragraph is in this GAR purchase and sale agreement. For those of you that will remember the show Hogan's Heroes and Sergeant Schultz. Sergeant Schultz was the sergeant who always said, I know nothing, I see nothing. So I like to refer to this disclaimer paragraph as the Sergeant Schultz paragraph. If you're not familiar with Hogan's Heroes, number one, you're making me feel really old. And number two, I don't know what the number two is, but anyway, I'll just change it to this paragraph is nothing is an issue until it's an issue, but you'll be glad this is in here. So all of this underlined, basically what it says is that the parties, meaning the public buyer and seller, have not relied on agent advice. The buyer needs to check out anything that is important or of concern to the buyer with respect to the contract and to the property. The seller needs to seek independent information regarding their position per the contract. The parties are to understand that any special stipulations that they have written, let me just show you this. This says, if the broker has written any special stipulations herein for the party with whom the special stipulation was written, the buyer must agree to it. There's an indemnity and hold harmless language, but this says that hereby adopts each special stipulation as the original work of the party. That's just a little thing in there that means you can't sue GAR even though it's in a GAR contract because that special stipulation was written not necessarily by GAR. And the buyer, further on in that paragraph, it states that the buyer acknowledges that any answers to their questions are information from the seller. You guys, that takes you off the hook. That means that if a buyer or a selling agent asks a question about the property and the listing agent answers that question, what that means is that listing agent is merely conveying information about the property that the listing agent received from the seller. Now, it does go on to say that if it is information from the listing agent, him or herself, that needs to be disclosed, that that information is specifically from the agent's knowledge. Contract tip for you guys, there is a GAR form, F325, Broker's Information Disclosure. It's just a fill in the blank form where you fill in the question, give the answer, and then you specifically cite the source of that answer. Again, that will protect you if something becomes an issue later on. All right, moving along. Ming, thank you so much. I see, I'm glancing over to the chat and I see that Ming is answering a lot of questions. If there are other questions that I need to address in the actual audio, because we are being recorded, Ming, if you will let me know, especially not necessarily every question, but if there's a question that's coming up repeatedly, just text me like you did. I appreciate that. And I will address that in the context of the class.
I'm here too, Dana.
Sorry?
I'm here too. It's Michelle.
Oh, hey, Michelle. Awesome. I will also stay on during the break as well as after class to answer whatever questions anybody has. Okay, moving along to the time limit. You guys, for whatever reason, I am not sure why, this is seems to be widely misunderstood what the time frame is in the purchase and sale agreement. So you fill in the time frame on the first section, paragraph A11, and this is where the explanation of it is in paragraph B11. For whatever reason, a lot of agents think that that time frame is the time frame within which the other party has to respond. That has nothing to do with it. A party can respond, well, it's only a time frame for the receiving party to accept the contract or the offer with no changes and send notice of acceptance back to the other party. So if you're making an offer or a counter offer, so if the receiving party is going to make a counter offer, the time limit doesn't matter because it's only to accept it with no changes and send it back. So let's say a buyer makes an offer to a seller. A seller can make a counter offer at any time. A seller can make a counter offer prior to the time limit. A seller can make a counter offer after the time limit. A seller can make a counter offer days after the time limit. The time limit is of no consequence if the seller is going to make a counter offer. This is true also if you are countering. So let's say a buyer makes an offer to a seller, seller makes a counter offer to a buyer, because there's a time limit, there's a time limit space in the counteroffer form as well. Again, it has nothing to do with responding unless that response is acceptance. So if there's no time limit on a contract, and if you guys are dealing with institutional sellers, for example, if you're writing a contract on a HUD home or a bank REO, you probably don't want to put a time limit on there because those sellers typically only work Monday through Friday, 9 to 5, and even more limited hours right now. But if there's no time limit, just remember you must withdraw that offer or counteroffer to take it off the table. So if a buyer makes, let's say a buyer makes an offer to a seller without a time limit, and you don't hear. Well, even 5 days later, let's say, that if the seller signs that, then the buyer and seller are under contract. So if you write an offer with no time limit, you must remember to withdraw that offer to take it off of the table if you're moving on to another issue or another property. There is a GAR form F-285, which is notice to withdraw the offer or counteroffer. Notices. All right, let's talk about notices. This is all spelled out in paragraph C1 of the purchase and sale agreement, and all of these issues that I have underlined is what I'm going to talk about. So notice must be done in writing, in person, by delivery, certified or registered U.S. mail, fax, or email. There is nothing in here about a phone call. So a phone call, and how do you make a text? What device do you use to send a text? You use your phone. Therefore, text messages are not considered in writing. Even if you transcribe a series of text messages onto an email, that is not considered in writing. So in the case of email, email is received when the sender can prove they sent it, regardless of when the receiver reads it. And it must be emailed or faxed to the address on the signature page. Therefore, make sure that your email and fax number on the signature page is what you actually use to conduct business. In FMLS and Georgia MLS, a lot of your broker information or your own information auto-populates on the signature pages. For example, if your broker has a corporate fax and that fax number pre-prints on your purchase and sale agreement, as an agent, you may want to take it off because typically those corporate faxes are only monitored Monday through Friday, 9 to 5. And a lot of you guys work on the weekends and in the evenings. So if there is a counter offer with a time limit or a termination and that is sent to your corporate fax number, because that fax number is printed on the signature page, that serves as notice, but you may never know about it. So check the signature page of your purchase and sale agreement and make sure that your email and fax number are the ones that you are actually working with. Now, further in the notice section, it does further state that if there is a client relationship, which we have discussed, then the broker, the agent, or any of the staff at that brokerage may accept notice for the for that party of which they have a client relationship with. Therefore, on the signature page of your purchase and sale agreement, if you are working with your public person as a client, you do not need to put their email address or fax number on there, but make sure your broker has it on the listing agreement or buyer brokerage. Now, if it's a dual agency situation, however, notice must be sent to the clients themselves as well as to the agent. So they, you would have to have their public information on the purchase and sale if you're in a dual agency situation. And if it's a designated agency situation, notice must be sent to the specific agent representing the party. Now, it further goes on to state in this paragraph here that if there is a customer relationship, notice must also be sent to the buyer or seller directly. So again, that information, the email address and or fax number or address is required on the contract for purposes of being able to send notice. Now, if you guys, if there is a contract and it indicates that a brokerage is working with the public in a customer relationship, it doesn't give you permission to cross a sign. You still must also communicate with that agent. That public person has chosen that brokerage to work with. So it doesn't mean you can talk directly to the other public person. Just for purposes of notice, you have to also send it directly to the customer. All right, now let's talk about default. This is in paragraph C2 of the purchase and sale agreement. And this is all outlined here. This was changed in August of 2018. Basically, if the buyer defaults on the contract, the only recourse or the only seller's sole remedy is to get the earnest money. That's it. So you sellers, when you guys are negotiating contracts, you need to take a look at how much that earnest money is, because if the buyer defaults, that's your only recourse for liquidated damages. If the seller defaults, the buyer has an option. Either the buyer may terminate the contract and get their earnest money back, or the buyer may sue for specific performance. Specific performance means you're going to go to a court and a judge is going to, if you win, if the buyer wins that case, the judge would require the seller to sell the house to that buyer. Now, not for free, the terms of the contract still come into play, but if a buyer is going to sue a seller for specific performance, they don't get the earnest money back. It goes to court and the earnest money is still on hold with the holder. But nowhere in here does either party have the right to sue the defaulting party for damages, for any expenses, any money spent on roof inspections, appraisals, moving fees, movers, lost leases. None of that, the buyer nor the seller can sue the other for any of those damages. These are the only remedies for default. Now, the brokers may pursue the defaulting party for the commission they would have earned had the contract closed. And again, as I said, all contracts belong to the broker. Therefore, it is only the broker that may legally pursue action against the public. Now, you guys as agents, you need to check with your brokers. A lot of times, an agent may send a demand letter to the party, but when it actually goes to court, you have to make sure that your broker would agree to actually pursuing the legal action against the public buyer or the public seller, whichever had defaulted. Now, the parties, again, I just said this, parties may not sue, that should be sue, not do, each other for damages. Okay, moving along, risk of damage to the property. What this states, this paragraph, a lot of times agents are asking me where this paragraph is. It's under risk of damage to the property, but there's a lot of information in here. Number one, it says the property must be in substantially the same condition at closing as it was on the offer date. This got changed in 2020. This used to say binding agreement date. It now says offer date. And that includes items that are indicated as staying with the property. It must be clean and free of trash and debris and items not negotiated to stay with the property. If there is, so again, it used to say, a lot of people add this as a special stipulation. You do not need to add this as a special stipulation because this is already included in this paragraph C3. If, however, there is substantial damage to the property, whether that be caused by a weather-related event or an act of vandalism or an accident or something like that, the seller, all of this part right here states that the seller must send notice to the buyer, and then either party may terminate. I don't know how to get these slides different, but and then if they don't terminate, the seller is obligated to repair the property and then give notice to the buyer that it's repaired. If the seller does that, then the parties must close within 7 days of the seller sending the buyer notice that it's back and restored, or within a year, whichever is shorter. All right, other provisions. Okay, I'm going to get to the end of this and then we will take a break. The entire agreement or modification, basically what this states is after the contract is binding, it may only be changed in writing and signed by the parties by an amendment or a notice of termination. There is a unilateral notice of termination that a lot of agents are more familiar using, or there is a mutual agreement to terminate. And the only difference is in the mutual agreement to terminate. Number one, it's not terminated until you have both buyer and seller signatures on the termination portion, as well as the agreement to disperse earnest money. The other issue is in the mutual termination, it also requires the selling and the listing broker to sign. So this would indicate that basically this mutual termination agreement is in essence an out-of-court settlement agreement where everybody figures out who is paying whom, how much, and then it is terminated, and all the parties forfeit any rights to pursue legal action against the other party. All right, also under this paragraph, it talks about assignment. And for any of you working with investors, the GAR purchase and sale agreement in and of itself is not assignable. The seller must agree in writing if the buyer, and a lot of times we have investor buyers who will go under contract with the seller and then look for another buyer to assign the contract to. You cannot do that unless the seller agrees. And you would use this GAR form F279, assignment of purchase and sale agreement rights. Extension of deadlines, we already talked about that. And no authority to bind. This means that brokers and agents may not sign anything or send emails that will bind the public to terms. So for example, when you guys are discussing repair issues and you say, yeah, my buyer will do that, my seller will do that, and you do that in email, that has no bearing on the buyer or the seller or the contract whatsoever. So if you get an email from the other agent stating that the public person will do this or not do that, it is not enforceable. There is no authority to bind on behalf of the agents or brokers. It needs to be in writing, signed by the buyer and the seller. Statute of limitations, this is a brand new paragraph in 2020, and basically there is a 2-year statute of limitations for a public person making a legal claim of breach against the contract. Now, survival of closing. Let's talk about this. It is very specific. In other words, what survival of closing means is that the obligations of the buyer or the seller legally continue after closing. And what this states is, here's where the paragraph is. It's paragraph C4I or L. And basically what that states is the only things that survive the GAR purchase and sale are commission. Yay, we get paid. Warranty of title. So this means we close a transaction and for whatever reason, the brokers weren't paid commission. The brokers have a legal right to pursue the public people for commission after closing. Survival of closing, warranty of title. The title that the seller warrants survives closing. Seller representations of the property. Anything a seller put in writing representing the property survives closing. That's the reason we have a lot of sellers that won't complete that seller's property disclosure. If a property has been condemned, that condemnation action survives closing. And then here is where it says here, any obligations which the parties herein agree shall survive closing. That's why this is a magic phrase. This provision shall survive closing, because that makes whatever the buyer and the seller agreed to pulls that into that survival clause, and that issue would survive closing. So we talked about it in terms of repairs, but you would probably put that if the buyer and the seller negotiate for the seller to pay for a home warranty for the buyer, because if it got missed at closing, the seller wouldn't be obligated to pay for it for the buyer unless you included that magic phrase. All right, moving along, binding agreement date. This is notice of acceptance. So the party that makes the last offer or counteroffer is the party who binds it, because the party makes the last offer or counteroffer. And so let's say, just for an example, let's say I'm a buyer. I write an offer or a counteroffer to the seller. Okay, so I wrote an offer to the seller. Seller wrote a counteroffer back to me. I wrote a counteroffer back to the seller. The seller signs it. we are not binding at that point because there's no notice of acceptance. We have acceptance, but not notice. So then the seller sends that acceptance back to the buyer, and that's who binds it, notice of acceptance. So the party making the last offer or counteroffer technically is the one who binds the contract. Now, the party making the last offer or counteroffer may withdraw it prior to receiving notice of acceptance. So in my last example, buyer writes an offer to the seller. Seller writes a counteroffer back to the buyer. Buyer writes a counteroffer back to the seller. The seller signs it but has not sent it back. The buyer can then withdraw that counteroffer. So it's not binding until all parties know that it has been accepted. And regardless of what date is filled in on the purchase and sale agreement, the binding agreement date can be proven beyond the shadow of a doubt based on the notice section discussed earlier. For example, by email, it is deemed received when the sender can prove they sent it. Also, just to let you know, the term broker is defined in the purchase and sale agreement. So anytime the purchase and sale agreement uses the term broker, it means the qualifying broker, the actual firm, or you as the affiliated licensee. Also, business days are defined as Monday through Friday, no weekends and no federal holidays. It's also known as banking days. If the contract just says days, it refers to calendar days. You also must disclose any material relationship. That's a family, business relationship, or a past client. So there's a lot of contracts where agents don't disclose a material relationship with a past client. Just think, if you have to ask yourself, is it a material relationship? Then you probably should disclose it. Cyber fraud. As I mentioned, cyber fraud is a huge issue in our industry for agents, lenders, and closing attorneys. The cyber fraud paragraph in C6 has a huge warning to buyers and sellers not to trust email with wire instructions. Because that's in there, y'all do not email wire instructions. We're telling the buyer and seller not to believe it, so don't send it to them by that method. Tell your public to cross-check and verify with a third party. If they get an email with wire instructions and a phone number in that email, don't call that phone number. It's more than likely false too. Go to Google and look up the closing attorney. Look up the brokerage. Don't email wire instructions. Send them via US mail or in hand. If the earnest money is to be wired, again, negotiate a longer time frame for the buyer to remit the funds. Don't even share wiring instructions from the closing attorney. Let the closing attorney address that directly. You should have a wire fraud disclaimer on your email signature. You can get that from your broker or from an attorney. Again, wire instructions should be delivered to the public by hand, US mail, or analog fax. An agent should have wire instructions for their broker and closing attorney on hand. So when you first meet with them, you can actually hand those wire instructions to your public people. So when you go under contract, there won't be a delay if they're wiring in earnest money. Also, warn your clients not to trust any changes you get by wire instructions by email or text. Now, just finishing up, the limit on broker's liability. GAR put this all in bold and in caps, and basically it says that the buyer and seller acknowledge that the broker, also you by extension as the affiliate licensee, have no liability greater than whatever commission you got paid, and if there was not a commission that got paid, greater than $100. This is for any liability with respect to the contract or any loss of funds due to cyber fraud. Now, I'm just letting you guys know this does not hold up if you have committed fraud. But if you have not committed fraud, which none of y'all will, then the liability, legal liability, is only the extent of the commission or $100. Now, when it talks about the exhibits, it does clearly state right here that the exhibits supersede the purchase and sale agreement. And now this gets confused by a lot of agents. If the exhibits are included, attached, or referenced, then they are part of the purchase and sale agreement. All exhibits and or addenda attached, listed, or referenced are made part of this agreement. So make sure you check those check boxes to reference them. so that when you're sending a document, if for whatever reason you don't necessarily send the actual exhibit, it's still part of the contract. So if you are receiving an offer and you look at this exhibit page and there are exhibits referenced, but you have not received them, for example, let's say the Community Association disclosure exhibit, there's a check mark saying it's part of this contract, but you do not have it or it's not filled out by the buyer, don't have your buyer sign that contract, because whatever's in there is still part of the contract. So all parties are going to want to know what is contained in those exhibits. And then under special stipulations, it states special stipulations supersede the purchase and sale. And again, an admonition is don't write special stipulations that address an item already addressed, because they supersede. That's going to counteract anything that was already in the purchase and sale agreement. And now just with respect to signatures, you have to have all buyers and sellers sign. I addressed that earlier. Agents must include license number and firm number. You really need to include the mailing address for your closing attorney, and for notice information, you need an address, an email, or a fax. Customers must include address or email or fax. And the binding agreement date, you're going to fill this in just so everybody's on the same page. But again, it can be determined beyond the shadow of a doubt per the notices section. All right. Before I go here, I think we should take a break. Well, you know what, let me cover this and we'll take a break. The counteroffer form. There's a lot of confusion on the counteroffer form. Basically, we have a question on if a buyer writes an offer to a seller, that's going to be on a purchase and sale agreement, and then the seller is going to use this counteroffer form F249 to make a counteroffer back to the buyer. So it states the original offer is hereby incorporated by reference. However, the only differences from the original offer is whatever is addressed here in this counteroffer. The counteroffer shall modify and control over any conflicting or inconsistent provisions in the original offer. When the counteroffer is signed by the buyer and the seller and a copy delivered to both parties, a legally binding agreement is formed. Since the original offer and all exhibits are incorporated by reference, only this counteroffer needs to be signed to create a legally binding agreement. We have so many questions about a buyer writes an offer to a seller writes a counteroffer back to a buyer signs it, sends notice of acceptance back to the seller. Then the question is, well, does the seller go back and sign or initial the exhibits? The answer is no. It states they're already incorporated in the contract. There is absolutely no need for a seller to go back and sign or initial exhibits. The problem is our lenders. What do the lenders want? Yep, you got it. The lenders want those seller signatures, especially on those loan documents, on the loan exhibits. Well, you have to be careful to make sure that there was nothing that was countered in the counteroffer form on those exhibits, and they're not required to be signed. But because we have lenders and the lenders are the ones that are controlling the loans to the buyers, the best way to handle this is to do what's called a clean copy of an agreement. So basically what a clean copy means is you pull out a blank purchase and sale agreement and you look at the terms of the original offer plus the counteroffer, and you pull that all together on a blank purchase and sale agreement, and everybody signs it. And a contract tip, hang on, a contract tip for that is, okay, hang on, I'll get to that in a second. These in general are exhibits that already should have had a seller initials on it and be available to the buyer. The seller's property disclosure statement, the community association disclosure, and the lead-based paint. So those really shouldn't be issues, because they really, you buyer's agents, you really should already have these filled out and signed by the seller in order to include those in your offer. EPA, again, it is an EPA federal mandate that the lead-based paint exhibit be completed and signed by the seller and buyer prior to going under contract, and that the buyer has received this lead-based paint pamphlet. The EPA fines brokers and agents $16,000 per missing initial or signature. Okay, so back to the discussion. If a lender wants a financing contingency signed, best way is by creating a conformed or clean copy. And basically what you do is you complete a purchase and sale agreement with all the exhibits and all the terms that reflect the actual final agreement. Now, here's my note of practice, point of practice to you guys. If you're going to do a clean copy, add this GAR special stipulation 622. Buyer and seller acknowledge that the above agreement is a conformed copy. Conformed is just a fancy word for clean, of an agreement between the parties dated blank, and that would be the binding agreement date. In the event of any conflict between this conformed agreement and the original thereof, all parties agree that the original agreement shall control. And then just go ahead and write conformed copy on the front page of the purchase and sale agreement. Woo! All right, you guys, now let's take a break. I've got 11:17. Let's come back at 11:30 a.m. And I am going to stay on and answer questions. So we're going to take about a 15-minute break. Come back at 11:30 a.m. When you come back in the chat box, please type in your name, email address, real estate license number, and if you are attending by phone, your cell phone number, in addition to all of that information. All right, everybody, go take a quick break and we'll see you back shortly. And if anybody wants to ask questions, just unmute yourself and I'll be more than happy to ask questions. I'm gonna take a look at the chat also. Thank you.
Just go to the chat and see if
Z reporting from Mineral Bluff.
Hello, John Z. We're going to have you talk for just a few minutes when we get back.
Okay, perfect.
Okay, there is a question. Okay, there was a question about emailing of wire instructions from closing attorneys. Some closing attorneys and some of your lenders do have encrypted email where they are sending confidential documentation through their encrypted email. I would encourage you working with the public, even sellers. You guys, sellers are have instructions for their proceeds and things like that. So it's not just a buyer issue. But if your closing attorney or your lenders are using encrypted email for wire instructions or anything else, please, please, please advise your public people to cross-check and verify from a third-party contact. So for example, if they're getting email from the closing attorney with wire instructions, before acting upon that, your buyers need to pick up their telephone, go to Google ABC closing attorney, find their number on Google, call the closing attorney and say, hey, I need to verify the closing instructions, wire instructions you just sent me, and confirm them through a source outside of what they have received.
no.
Hey, Dana, if you're able to mute Dawn. Oh, there we go.
I just
got
did.
it.
All right.
Hey, Dana,
Yes.
I got a quick question. This is Steve Joseph. It's good morning.
Good morning.
I have a question. So something about whether it's certified funds or a check or a actual wire for proceeds, sometimes and even deposits. I have conflicting question about this. My attorney says there's some statute with Georgia that he cannot take any personal or certified checks of any amounts over something. I forget whether it was a couple $1,000 or something. And then the question is, we won't do a closing unless it's, a wired amount. But then I've seen attorneys at closing receive a certified check and say nothing about it. So what's your thoughts on that?
My thoughts on that are you need to check with the closing attorney regarding what their policies are. Like any laws on the books. Well, let me ask you, Steve, what is the posted speed limit on I-75?
What, 75?
No, I don't think it's that fast.
65?
So let me ask you hypothetically, not you yourself, but do you know perhaps of others that might exceed the posted speed limit?
Yeah, one or two.
Hypothetically.
Yeah.
So is that breaking the law?
Yeah.
Do people do it anyway?
Yeah.
Are there any consequences unless someone is charged with the violation of breaking
Yeah.
the law?
I get it. I get it. So I was just curious in your practice though, what is there regarding payments? When you advise your buyers to fund, they got to get the money to the closing attorney?
So in general, in dealing with money from the public to either a broker or a closing attorney, whomever, when you're talking about earnest money, you need to check with the holder, whether that be the broker. When you're talking about proceeds or cash to close, and you're dealing with the closing attorney, or if the closing attorney is holding earnest money, you need to check with their policy. It becomes a policy issue for the brokerage. For example, and I address this, I think, later on. For example, many brokerages will require certified funds over $5,000.
Right, exactly.
Now, I will tell everybody, if a public person has on deposit, now not for closing, not for proceeds, and not for cash to close, but earnest money on deposit of $10,000, of more than $10,000, whether that be in one payment or additional payments, the holder must complete IRS form 8300 that has a lot of, we need all this identity information, addresses, social security numbers, all that kind of stuff, if the form of those funds is in a personal check or certified funds or a money order. We do not have to fill out, and that's a Homeland Security document. It's an IRS document, but it's from an order issued by Homeland Security. So if a public person is putting in earnest money of $10,000 or more, they absolutely want to do it by wire so that the holder does not require them to fill out that form 8300, which has a lot of personal identifiable information on there.
Which is exactly my policy too. So I just was curious because I've just seen different attorneys, so it kind of confused me.
Yeah, a lot of brokers, I know our brokerage, we won't accept a check, even a business check, for over $5,000. It must be $5,000.
Me too. Thank you, Dana.
You're welcome. There was also a question about notice. Yes, if notice is sent to an email address that is not the email address listed on the signature page of the purchase and sale, or is not corrected by formal notification shortly thereafter, then it does not serve as notice to the parties. So, if you're working with a buyer, for example, and you want to terminate a contract based on a contingency, you have the buyer fill out the termination notice and you send it to the other party, but you send it to an email address that's not on that signature page. The buyer has not terminated the contract and the buyer would be in default.
Hey, Dana, really quick.
Yes.
Now, if let's say you're the selling agent and
Okay.
you send a notice to the listing agent, and the listing agent responded back, say received, even though that's not the same email as is on the contract. But if you have a written email back to you stating receive or acknowledgement, will you be covered?
So that would be a good argument for that party's attorney to make in front of a judge.
Okay, thank you.
So I don't, I don't have the answers. The contract clearly states no, that does not serve as notice. But the other party acknowledged receipt of that. So on one hand, yeah, they got it. On the other hand, Ming, we just read that the agents and the brokers have no authority to bind the clients. So is that email acknowledgement from the agent, does that serve as notice being served? I don't know. I can make a legal argument. I can make a legal argument for anything. Not an attorney, but I can make the argument, no, the agent has no authority to serve. And then you're like, yeah, but there's a client relationship, so notice to the agent or broker serves as notice. Yeah, but you didn't send me notice, even though I acknowledged it. You didn't send me notice to where you were required to send me notice. But then the other argument is, yeah, but you acknowledged receipt, so that is notice. So I don't know. Again, don't leave it up to a judge to decide. Don't put yourself in that situation. Now, that contract, that notice section of the GAR also states that if, for example, the email address or fax number on the signature page of the purchase and sale is incorrect or changes, the party can send notice to the other party of a new email address or fax number that would serve as legal notice. And as long as you keep documentation of that, that is how you would correct that in advance. Again, nothing's an issue till it's an issue, but that's how that would be handled.
Right, and depending on the judge you have.
Exactly. We don't want to leave it into the hands of the judges, because you don't want to get a judge. You're going to have some judges that love us. You're going to get some judges that may have had a bad experience with real estate, and they're like, you're taking advantage of that poor public. So you don't, I mean, hopefully they don't do that. And hopefully they just go by the contract and by law, but we don't want to leave it in the hands of, we want to do everything we can in advance to prevent any issues from becoming an issue.
Absolutely. Thank you.
You're welcome. All right. No other questions? Either I'm talking too much or...
No, somebody did ask if you're going to put this on your regular YouTube page as well. So I kind of redirect them.
When they get posted, they go to my YouTube page, and I'll write that out. And then it's just the YouTube link that I link on that other page. Also, I have done a video on the mid-year changes that GAR made, but when I posted it, my sound is off from the video, so I have to re-edit it and see if I can get it matched up.
Was there any major changes on the?
Yes, there's two major changes that I'm going to address in this class. One is to the sale release contingency, and the other is to Form F510, the closing attorneys holding earnest money.
Great.
All right. All right, you guys, I'm going to have to talk a little bit faster. I'm going to talk a little bit faster so we can get through everything. So, all right, I am going to unmute John Zupancic. All right, welcome back, everybody. I am going to everyone and then go back and share the screen, and we are going to, I will stay on as long as anybody would like to answer questions at the end of class. And again, thank you all for who are participating, and thank you so much, Ming, for your wonderful broker answers on a lot of the additional, get rid of that, on the additional questions. All right, ready to move on? Here we go. Now, we're going to move on to the loan contingency exhibits. So I'm going to have a pretty thorough discussion on the conventional loan contingency exhibit, and then FHA and VA, the first part of those are the same. I'm just going to talk about the differences. So conventional loan contingency exhibit, Form F404. Per license law, if you are writing a contract and it is subject to financing, it is a license law violation against you, the agent, to make a contract subject to financing for a buyer and leave any of that blank. You must fill it all out. Additionally, for your buyers, if they're going to terminate under the financing contingency and try to protect their earnest money, the loan that must be denied is the loan that is described here in this information. If you don't know this information, the loan amount, the term, the interest rate, you need to get that information from the buyer's lender. If you don't know who the buyer's lender is, then you absolutely have no business writing a contract for them until you know they have been qualified. All right. Also, it clearly states in this paragraph B, a buyer may apply for a different loan, but denial of a different conventional loan will not protect the buyer's earnest money. Again, the loan denial letter to protect the buyer's earnest money must be a denial for this loan as described. And then you guys, you listing agents, love, 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 love this. This is brand new in 2020. If again, we're on the conventional loan exhibit. If the buyer, it says they can apply for a different loan, but if they are going to apply for an FHA, if they're going to switch from conventional, FHA, VA, or USDA, they absolutely must get the seller's written approval if they're going to switch. Why? Well, those loans, those government insured loans, incur costs to the seller that the seller does not incur under a conventional loan. So a seller has to agree to a buyer getting a government insured loan before the buyer may do that. Now, here's the contingency part on paragraph 5. Basically what a contingency means is any contingency, but specific to the finance contingency, the seller gives the buyer X number of days from the binding agreement date to convince a lender to lend them money to buy the house. If the buyer can't do that, they can't tell the lender, look, I'm a good risk, I promise you, lend me this money and I'll pay you back. It might take me 30 years, but I'll pay you back, and I'll pay you back with interest. If the buyer cannot convince a lender that they are a good risk and will pay them back, then the buyer must terminate the contract prior to 11:59 p.m. on the last day of whatever that time frame is. And they have to prove it. So you can't just tell a seller, nah, I got turned down for the loan. Well, they have to prove they got turned down from the loan. But that proof is in the form of a loan denial letter. And in the GAR contract, that loan denial letter has to be sent to the seller within 7 days of the date they terminated. So look here, this time frame here, that's just the time frame to send the notice of termination. The buyer still has 7 days after that to send the proof, the loan denial letter. Even if those 7 days, so if they send the termination notice on, let's say we had 21 days here, and they send it on day 21, they would have 7 additional days to still send the proof. So even if those days fall after that contingency time frame. Now, the loan denial letter must be from one of the identified approved mortgage lenders if one was identified in paragraph 2. If there's nobody identified there, then it can be from anyone, any lender licensed to do business in Georgia. And now the proof, it has to be very specific. The loan denial letter may not be based solely on one of the following. In other words, the buyer's earnest money is not protected if the loan denial letter is based solely on the buyer not having cash for down payment or closing costs, buyer hasn't sold or leased their current home if the exhibit isn't included, and the buyer dragged their feet when the lender said, I need these documents, and the buyer didn't send them to the lender in a timely manner, or the buyer's actions after binding. For example, they bought stuff and damaged their credit, or they lost their job. So it's kind of adding insult to injury. Let's say they get a loan denial letter, so they're not going to get their loan, but the reason is because they didn't have enough cash for their down payment. Well, not only will they not get their loan, they're also going to lose their earnest money because they don't meet the terms of this financing loan contingency exhibit. All right, and that's where it describes all of that. It's in the second little section of paragraph 6 is where it states the loan denial letter may not be based solely upon those issues. Now, let's say the financing contingency time frame has passed. So for example, if we put 21 days in there, we're now on day 22 and the buyer didn't terminate. Yay! We're going to go through with it. Well, now there is a paragraph in the financing contingency exhibit that says the seller may request proof of ability to close. In other words, a loan commitment letter. And so first thing that has to happen is the seller sends notice to the buyer requesting this proof. The buyer then has 7 days to produce this loan commitment letter from the lender. If not, remember, we've got notice. If there's a default, then we've got a time frame to cure and then a time frame to terminate. So here we go. Seller sends notice requesting the loan commitment letter. Buyer has 7 days to produce. If not, the seller then sends notice of the buyer default. Buyer has 3 days to cure. If there's no cure, then the seller has 7 days to terminate. The issue is, this sounds all great for our sellers, but the problem is, I'm missing a T there, is we kind of run out of time. So for example, if we have a 21-day time financing contingency time frame and we're closing in 30 days, well, the seller can't even request this loan commitment letter till day 22. Then the buyer has 7 days to produce it. So we're on day 22, 23, 24, 25, 26, 27, 28. We're on day 29. If the seller doesn't produce it, the seller sends notice of default. The buyer has 3 more days, day 30, 31, 32. And then on day 33 is the first time frame the seller has to terminate. Well, we were supposed to have closed 3 days ago. So this looks good, and this will kind of come into play when we're in a slower market, but you just have to, that's what I mean about watching your time frames, is we might be out of contract before all of this plays out anyway. This is where all of that is contained in the contingency. This is in every contingency exhibit. Paragraph 7, right of seller to request evidence of buyer's ability to close, and then in the seller's right to terminate. All those time frames are spelled out there. Okay, now let's move along to the appraisal contingency. In the GAR contract packages, the appraisal contingency is located in all of the loan contingency exhibits. So in the conventional loan contingency, again, you fill in a time frame. If the property does not appraise for the sale price or higher than the sale price, the buyer has X number of days from the binding agreement date to send an amendment to the seller asking the seller to sell for at least the appraised price. And that's form F713, amendment to the sale price. In this exhibit, they use the initials ATSP, amendment to sale price. The buyer, so in the GAR conventional loan contingency, the buyer absolutely positively must give the seller the option to sell at the lower appraised price. Now, the buyer must send the seller a copy of the appraisal. And then there are additional time frames in this. So on that appraisal contingency time frame, that first time frame, again, a lot of agents are putting in 21 days or 28 days. A lot of you guys are making that number consistent with the financing contingency time frame just for ease of remembering dates. That time frame is simply for the buyer to send the seller the amendment to address the sale price. So after that, the seller then has 3 days after receipt of that amendment to accept it, reject it, or negotiate a new sale price. If they don't come to terms, the buyer has an additional 3 days to either terminate with no penalty, as long as those 3 days fall within 1 day before contract. If the buyer doesn't terminate, so buyer sent the amendment to the seller to sell it for lower. Seller says, nope, I'm not selling it for lower. The buyer doesn't terminate. In that situation, the buyer is obligated to buy the property at the higher contract price regardless of the appraisal. So the buyer's going to get the loan for a lesser amount and would have to bring additional cash to closing. All of those time frames and all of that craziness is explained here in paragraph 11 of the conventional loan contingency. So that time frame that you negotiate right there, that is just to send the amendment to the sale price to the seller. But those other time frames are all explained after here. So there's a question about if there's another approved lender, can the other lender send the denial letter? So again, you guys are having your buyers that are shopping loans and going to other lenders, and that's fine. However, it depends on when the buyer and seller went under contract. Oh shoot, I'm going the wrong way. When the buyer and seller went under contract, under that section where it talks about approved mortgage lenders, if when you go under contract, and I'm sorry I'm going through these quickly, I'm trying to get to that section so I can show to you where it says, but if under that section where it talks about approved mortgage lenders, and this is in conventional FHA, VA, and USDA, if there is a lender identified in here or more than one, that loan denial letter absolutely must come from that lender. If there is no lender identified in here, then that loan denial letter may come from any lender approved to do mortgages in Georgia. So if you're on a buyer side, it's probably in your buyer's best interest to keep this blank. If you are on the listing side, you probably want a name in here of a lender you know, love, and trust, or at least some lender. Now, there is another paragraph, I believe it's 3, where it does state that once a buyer does send the letter of intent to a mortgage lender, the buyer is to send notice of the mortgage lender to the seller of whom they are working. But that loan denial letter must come from an identified lender if that lender is identified. All right. Now, moving on to the FHA loan contingency exhibit, Form 407, same as the conventional up to the appraisal part. The appraisal in these government insured loans is called, in the contract it says it's the amendatory clause. There's no time frame in the FHA or VA loan exhibit, so the appraisal contingency protection for the buyer's earnest money goes through day of closing. In the FHA exhibit, however, you must fill in a dollar amount that the property must appraise for X amount of dollars. Remember, if you guys are going back and forth with counter offers and the buyer's getting an FHA insured loan, that you address this paragraph in the counter offer as well. Now, if a property does not, if buyer and seller are binding, buyer is getting an FHA loan, same for VA, and the appraisal comes in low, the buyer may terminate and get their earnest money back. They do not have to ask the seller to sell it for lower. Now they have the option to do that, but it is not required like it is in the conventional loan contingency exhibit. And again, this is the paragraph 11, the amendatory clause. Now, additionally, in the FHA loan, there are seller required fees, the tax service fee and a lender required inspection of the septic and well, if there is one on the property, and if the lender requires a home warranty if the property is less than 1 year. All of those fees are required to be paid by the seller. Now, if the appraisal or the lender actually requires repairs, and this is all spelled out in paragraph 15, then there is verbiage. Let me see if I have it. Okay. Repairs required in FHA commitment. This, you negotiate who's going to pay for those repairs and you put in a max amount. Do not exceed X amount of dollars. The problem is, what happens if those repairs, and for whatever reason, we always see $500? It's kind of crazy to me because on a sale price of a house that's $500,000, $600,000, $700,000, $800,000, there may be, well, I don't know if you're going to have an FHA loan on that. But anyway, if the actual repairs mandated by the FHA commitment exceed this amount, well, what happens? Well, that's all spelled out in this paragraph, which is new for the FHA exhibit in 2020. And basically what that says is if the actual repairs exceed the amount negotiated, the seller is required to get third-party estimate. The seller has to get that, send those estimates to the buyer. Then the buyer and the seller figure out who's going to pay for the overage from the amount that they had agreed upon and the difference. They have to agree upon that within 3 days from when the seller sends the estimates. If there's no written agreement via amendment within that time frame, then the contract terminates. That's what's all spelled out here. Now, further on, it does say that the property may be required required by FHA to be connected to public sewer, and the amount and is managed by, I just muted everybody, is managed by the buyer and the seller, and it must be an arm's length transaction, which means there's no relationship between the buyer and the seller. Now, this is in all the government exhibits, financing exhibits, exhibit controls. This exhibit shall control over anything conflicting or inconsistent set forth in any other exhibit to this agreement. It just has the word exhibit, but in essence, what this means is the buyer and the seller may not use a special stipulation to change anything in the FHA, VA, or USDA loan exhibits. For example, you can't change the time frame for the appraisal contingency. It goes through day of closing. You cannot special stip that out. This exhibit controls. All right. Now, going back to the conventional loan contingency exhibit, they used to have in a thing about lender required repairs, which was kind of odd in a conventional loan exhibit. They used to have that same thing, that if the repairs amount, and then if there was a difference, you negotiate through who's going to pay the difference, or it terminates. They took that out of the exhibit in 2020 and made that a special stipulation. So this is one of the two new special stipulations in 2020, that it just is basically the verbiage we just read in the FHA loan contingency. You can use that for a conventional loan if you choose. Now, moving on to the VA loan exhibit. It's the same as the conventional up through the appraisal contingency, and the same as the FHA through, again, that paragraph 11, the amendatory clause. The only difference in the amendatory clause of the VA loan exhibit is you don't fill in a dollar amount. It just states that it must appraise for a price deemed reasonable by the VA. Now, again, under lender required repairs, they must be paid for by the seller, and the amount is negotiated, but same thing. If the price exceeds this, then it's the same process to negotiate through that issue. The main difference between the VA loan exhibit and the other financing contingency exhibits is a VA loan absolutely requires a termite letter. This is paragraph 14. It has gone radical changes in the past 2 years, but the way it reads right now is that the seller must provide a termite clearance letter. The letter must be dated within 90 days of closing. If there's active infestation, the seller must treat or retreat and then provide the termite clearance letter. If the property, however, has been damaged from previous infestation, the lender may require that that damage be repaired. Same process that we've been discussing. Seller gets an estimate, negotiate who pays. If not, it terminates. That's all spelled out right here in this paragraph 14, VA rules and regulations, termite letter. The rest is the same as the FHA exhibit. Again, it may be required to be connected to public water and sewer, and this exhibit controls. You can't special stipulation out any of these issues. All right, one more new special stipulation. If you guys are working with a buyer and they want to buy a townhouse or condominium, we have found that many of those complexes are not approved for an FHA or VA loan. So instead of wasting everybody's time and spending money, there is a special stipulation that GAR has come up with in 2020 that states, it's special stipulation 526, notwithstanding any other provision to the contrary, if it is determined the property is in a real estate development that is not FHA or VA approved, the buyer may terminate this agreement upon notice to the seller and received a full refund of earnest money. Again, there's no time frames in this unless the buyer and seller negotiate this in the writing of the special stip. Okay, moving on to the all cash exhibit. Now, this is if a buyer is paying cash or if a buyer is getting a loan, but they're not making the contract contingent to them getting approved for the loan. So those are the buyers you want, buyers that they're going to apply for a loan, but you know it's not going to be an issue, right? They're no problem getting a loan from a lender. Or if a buyer is getting a hard money loan. Now, this exhibit has always been used in practice for agents working with buyers getting a hard money loan, but brand new, hot off the press, what's today's date? Just 6 days ago, GAR actually added the verbiage hard money loan in there. Oops. So again, I don't have a copy of this, but they've added, agents were using this for hard money loan also because the loan contingencies clearly state they are for an institutional mortgage. This exhibit also has a verification of funds time frame and options to negotiate between a buyer and seller, including an appraisal contingency. But this is the section that's new as of May 1st. Oh my goodness, community association disclosure. My. Such an issue for some buyers and sellers right now. Basically, the issue is the seller must complete and update this form with any changes. And there's a description of the association, and then paragraph 3, which is the majority of this exhibit, talks about all the fees. And basically, this document puts the burden on the seller, that the seller absolutely must disclose all the fees of the HOA, homeowners association, or management company to the buyer in this form. Then they put this in there not to punish the seller, but this is a lot of these associations will only talk to the seller. They won't talk to the listing agent, they won't talk to the buyer, and they won't talk to the selling agent. So it states in this form repeatedly in several different paragraphs of this community association disclosure, it states any fees not disclosed or not accurate, the seller will pay at closing, even if those fees are really buyer fees, such as initiation or transfer fees, so forth and so on. Now, again, the reason is not to punish the seller, but the seller is the only one who these management companies will discuss these fees with. It also states on here that these seller paid fees don't count as a contribution to the buyer. In other words, you know, if you have buyers and depending on their loan type, a seller or outside parties can only contribute a certain percent, like 4% or 6% to the buyer. These seller paid fees, if the seller does have to pay for any undisclosed or inaccurate fees, don't count towards that for a buyer. Now, generally speaking, what does a seller have to pay regarding the association? Well, the seller has to pay the closing fee and the clearance statement. Basically, they have to prove that the seller is in good standing with the association, paid up financially before selling the house. And the seller has to pay any fees that are already in place and due prior to the closing date, and any move-out fees, if any. Buyer fees are the transfer fee, initiation fee, admin fees, move-in fees, or any prepaid special assessments. But again, if the seller has not disclosed these to the buyer, then the seller is going to have to pay at closing, even though they're for the benefit of the buyer. Now, what about special assessments? Well, this form goes on to talk about special assessments. Ones that have already passed, meaning already voted on, ones that are under consideration, and ones that may come under consideration. So special assessments that have already passed, the seller must disclose, and the seller pays any portion of that due prior to the closing date, and the buyer's responsible for any portion of that due after the closing date. Again, the seller has to disclose what these are on this document so the buyer knows. Now, what about special assessments under consideration but not yet passed? That means they have been raised at an HOA meeting, so they're not, we know they may be voted in. Again, the seller must disclose and pay any portion due prior to closing, and the buyer would be responsible for any portion due after closing, as long as the seller disclosed them. Now, here, this part's new in 2020, and this is a little bit confusing, but basically, special assessments that come up by the homeowners association between binding date and closing date. Well, we're after binding, so the seller didn't disclose those on the form because they didn't know what they are, but we have to anticipate it in the future. So for example, if the HOA had a meeting between the binding agreement date and the closing date, and the assessments are discussed at that meeting, The seller must disclose them once they are discussed, and there's minutes from the HOA that talk about those. Any assessments that come up during this time frame that are voted on and due prior to closing, the seller must pay. Any voted on or in and due after closing, the buyer must pay. But since the buyer and seller go under contract now, and these fees will be discussed in the future before closing date, then there's a paragraph that states if these unknown fees become adopted and due and they exceed X amount of dollars, then the buyer may terminate and get the earnest money back within 5 days of receipt of notice from the seller. So basically, this is just in the instance when there is an HOA meeting between these two dates and fees are discussed, special assessments are discussed. You listing agents working with sellers, from the time your seller puts their house on the market until closing, the seller must stay aware of the HOA minutes from the previous meetings and current meetings. They've got to stay up on what's being discussed, especially if there are any fees that come into play. All right, I'm gonna quickly, I gotta go fast. The seller's property disclosure form, basically it's just intended to help a seller disclose latent material defects that we already discussed. The buyer is still responsible for inspecting and checking out the property and making sure that it is suitable. One thing for you agents, here's a hint. When you buyer's agents, when you get the seller's property disclosure form from the seller and the listing agent, look here at this paragraph 2, covenants and fees. If the seller has marked yes, you're going to want to make sure that the community association disclosure exhibit that we just discussed is also part of this contract. Also in the paragraph talking about fixtures, it states that any items remaining with the property, if the seller leaves something they weren't supposed to, so in this form, the seller said they were going to take it with them. But in the actual move, the seller decided they changed their mind and they're leaving it and they're not moving it. In that situation, the buyer may remove it and the seller is responsible for the cost. Additionally, any items that the seller says are staying with the property, if they're damaged or broken, the seller is obligated to replace them with the same or better. And look, GAR uses our magic phrase, this provision shall survive closing. Okay, sale or lease contingency exhibit, form F601. This was completely revised 6 days ago. The revision they did on this is wonderful, wonderful, wonderful. Buyers, listing agents, and selling agents are really gonna like this new form. Now, they have not changed the content of this form. They have just made it much easier to read and understand for buyers and sellers as well as for agents. So first of all, you must fill in this contingency time frame. It says this agreement is contingent upon the following occurring before. You have to fill in this date. Don't leave this blank. Either the buyer, so this is a buyer, I want to buy a new house, but I have to sell my house I'm living in now. I have to sell that. My contract on the new house is contingent upon my selling my current home within this time frame. This is key. You've got to fill in this date. Don't leave that blank, or a lease. Now, if I don't sell my house before this time frame, then my contract to buy my new home terminates automatically and I'll get my earnest money back. But if I'm getting close to this time, before this date happens, I can remove this contingency. So for example, let's say I get a contract on my current house and the time frames get a little wonky and extensions happen with that one. I don't want this current contract to automatically terminate. So I can negotiate this or waive this. So I know I'm under contract, I just haven't closed it yet. So that's what all of that is about. That's the same. Now, what they have revised is this kick-out paragraph. And again, conceptually, it is the same. The seller may continue to offer the property for sale and accept another contract, but first give the current buyer the option. So basically what happens, seller buyer has to sell their house they're living in now in order to buy this new home. The seller says, all right, I'll go ahead and go under contract with you and give you the opportunity to sell your current home. But in exchange for that, you have to allow me the opportunity to continue to offer my home for sale and sell it to another buyer. If I find buyer number 2 that I want to deal with and want to sell it to, I have the opportunity to do that. But if I find buyer number 2 that I want to sell to, I'm already under contract with you. So I have to go back to you first and say, are you going to stay in contract with me, or are you going to terminate and let me go and sell my house to buyer number 2? Well, buyer number 1 says, nope, I love this house. I'm going to stay in contract with you. And the seller says, okay, well, you have to make your deal a little bit stronger. If I'm going to stay in contract with you and not go to buyer number 2, I'm not going to kick you out, but there are some contingencies that are going to be removed to make your contract a little stronger. So I'll get to those in a second, but that's what the essence of the kick out is. The seller can kick out the buyer if the buyer doesn't want to stay in contract. But here's a note to you listing agents. If you get buyer number 2 that you want to negotiate with, do not exercise your kick out to buyer number 1 and then negotiate with buyer number 2. Because if you never go under contract with buyer number 2, you are back on the market with no contract. So you listing agents, if you are under contract with buyer number 1 and there is a sale or lease contingency on that contract and you get offered from buyer number 2, fully negotiate that contract with buyer number 2 and just include the backup contingency exhibit prior to exercising the kick out to buyer number 1 so that you're not left without any contract whatsoever. Okay, that's just a note for practice. Now, this is what the kick out is explained. Now, let's see what the actual kick out is. So if you're under contract and there's a kick out, so buyer number 1 knows they can be kicked out. Seller gets offer from buyer number 2. They go back to the buyer. This contract is subject to a kick out. The seller receives offer from buyer number 2. They go back to buyer number 1 and says, okay, I've got another offer. I'm either going to kick you out or you're going to stay in. You have to let me know if you're going to stay in contract with me so many hours after I send you notice that I'm going to kick you out. You can negotiate for additional earnest money. So if buyer number 1 says, nope, I love this house, I'm going to stay in it, I don't want to be kicked out, but I'm going to make my offer stronger by removing some contingencies. So either you can negotiate that all contingencies in favor of the buyer are removed. So seller wants to kick out the buyer. Buyer says, nope, I'm staying in contract. If this option is selected, the buyer must close with the seller. If not, they would be in default. All contingencies are removed. Or they can just negotiate to remove certain contingencies. Look, I'll stay in contract with you and I just won't make it contingent upon my house selling. In other words, this is a buyer who I live in my old house and I want to buy a new house. Financially, I can afford both mortgage payments. I just don't want 2 mortgage payments. But I'm able to go through with the purchase of the new home, even with a mortgage on my home. So I might just want to remove this sale or lease contingency, but I still want to keep in my due diligence period, my financing, my appraisal, or any other special stipulation. So all of that was changed the beginning of this year, but in May 1st, what they changed is it was a little confusing. If you checked these boxes, did that mean those contingencies remained with the contract or were eliminated? So GAR cleared that up for us May 1st, 2020, and it says the contingencies and or due diligence period checked below shall no longer be part of this amendment. And again, the buyer and seller can negotiate that there's no kick out. So if you're working with a buyer, you would want this option. Once the seller goes under contract with me, they have to wait until I sell my house. If you're working with a seller, you want the option to sell it to someone else and perhaps have the buyer remove those contingencies. But that's the change, is the way they have formatted this exhibit. And this one sentence right here really clears a lot of issues up, that the items checked below shall no longer be part of this agreement. All right, that's what we just talked about. Now, moving along to the backup contingency exhibit, which is form, I got a F604. The backup contingency exhibit, there is a place in there where you must identify the primary contract. Therefore, you buyer's agents, when you're talking to a listing agent and they say, I've got 5 backups, that's not true. You can only have one backup contract because the backup contract must identify the primary contract. You can have one primary and one backup. Now, they may have 5 interested buyers, but there can only be one backup contract, and it would be fully negotiated with the inclusion of this backup contingency exhibit. Now, on this exhibit, the binding agreement date is just like any other contract. It is the date that all parties sign and agree to terms, and notice of acceptance is conveyed to the party making the last offer or counteroffer. Therefore, earnest money is due per the terms of this binding agreement date. So in the purchase and sale, if it says buyer to remit earnest money 3 days from binding agreement date, even in a backup contract, that earnest money is due 3 days from the binding agreement date, unless you write a special stipulation addressing earnest money. But all the other contingency timeframes, your financing contingency, your appraisal contingency, your due diligence timeframe, all the other contingency timeframes other than earnest money begin when the seller sends notice to this buyer that the primary contract has been terminated and now this backup contract is primary. So all of that is spelled out in this paragraph here under the backup contingency exhibit. If the backup buyer never gets notice that they've been made primary, then this contract automatically terminates. And you can fill in a date also. And the buyer, if this terminates, the buyer would get their earnest money back if they had put in earnest money. All right, closing attorney acting as holder of the earnest money. This form also was changed in May 1st, 6 days ago. So first of all, this is, again, we talked about this at the very beginning. This form is an exhibit and is included with the binding contract. That if the parties identify a closing attorney, you have to include this exhibit. And it clearly states that the buyer must deliver the contract to the attorney within 2 days of binding agreement date. The closing attorney then must agree to become the holder within 3 business days after receiving the contract. Now, here's what got changed, brand new in 5/1. And I'm telling you right now, our brokers, we love this change. It states that the earnest money must be paid to the closing attorney acting as holder by wire. It used to say wire or ACH transfer. So that's still the label of the paragraph. However, look at what it got changed to. Buyer shall be responsible for paying all the earnest money and the other buyer trust funds to the closing attorney acting as holder by wire transfer of immediately available funds or by such other method deemed acceptable and or required by the closing attorney. You guys, what was happening is that last phrase was not in there. And we had closing attorneys that were accepting checks as earnest money, and it all of a sudden put the buyer in default of the contract and necessitated an amendment between the buyer and the seller because the closing attorneys weren't reading the documents and were accepting earnest money by other forms. So GAR has brought that back in where we don't have to write those amendments anymore. Now, this form also states, and this is, that was the only thing that was changed May 1st. If it's an all cash transaction and the contract terminates and there's a dispute regarding the disbursement of earnest money, we talked about this. In other words, both parties don't sign the release portion of the TNR. The attorney must interplead the funds. Remember I talked about all those fees involved? The attorney does not have the option to send the 10-day letter and interpret the contract. All cash, only remedy is to interplead. So that becomes expensive for your buyer and your seller in an all-cash transaction if they elect the closing attorney to hold the earnest money. Now, also on this form, you guys, you must name an alternate holder. And it has to be either the selling or the listing broker. Because if the attorney won't hold the earnest money, you have to have a holder of the earnest money. A lot of attorneys won't hold earnest money if it's too small of an amount. A lot of attorneys won't hold the earnest money if they have a previous client relationship with one of the parties. A lot of attorneys won't sign the other form, the agreement, without the earnest money in hand. Another thing to consider, you guys, your closing attorneys, unless they hold a real estate license, they're not held to license law like brokers are. Now, they can't do anything illegal with the funds, but their license can't be sanctioned like a broker can if they do something with the disbursement of the earnest money. Now, after that form 510 is an exhibit to the contract. 511 is what the attorney signs. And it's just an agreement signed by the attorney agreeing to fulfill the responsibilities as holder of the earnest money. Okay, moving along, amendment to address concerns with the property. Okay, this is the form. Remember, we talked about if the contract is subject to due diligence, the buyer has to decide, am I going to terminate or am I going to go through with it? Well, to help me make my decision to stay in contract, I'm going to have an inspection done. And I found some things that, you know, I'd really like for the seller to address these items to help me decide to stay in contract rather than terminate. Now, there is a new paragraph, January of this year, that says this amendment is intended to set forth the agreement of the parties' concerns raised by buyer and seller during due diligence. If it does not become effective during due diligence, it shall be null and void. Basically, what that means is both buyer and seller must sign it, and there must be notice of acceptance before the end of the due diligence period, or the seller is not obligated to perform those repairs. In essence, this phrase right here, this paragraph, creates a time limit for this amendment. This is the only amendment that has a time limit referenced or built into it. So if a buyer sends over issues for a seller to address some repair items, and then let's say the seller sends a counter amendment back to the buyer must agree to those and send it back signed prior to the end of due diligence, or the seller is not obligated to perform those repairs. There's also a phrase in this amendment to address concerns that if the parties both agree to the repairs addressed, then this can end the due diligence period sooner. Again, you would mark out if the buyer, basically it says seller agreeing to certain repairs and sending notice of that, the buyer and the seller, the remainder of the buyer's due diligence period shall or shall not terminate. Now, again, repairs don't survive closing unless you use the magic phrase, these items shall survive closing. And again, we've already talked about this. You must address buyer's recourse if the seller doesn't do the repairs. Go to eagentweb.com, click on training videos, and there is a handout called Repair Special Stipulations to Consider. All right, a T&R. Again, the notice to terminate, I addressed this earlier, you only need one party to sign it, but you do need both party signatures agreeing to disperse the earnest money. I've already addressed the holder has various options if the buyer and the seller do not agree on who gets the earnest money. Now, the mutual T&R, again, I addressed this a little bit earlier. It does require both mutual versus unilateral, both buyer and seller signatures to terminate, both buyer and seller signatures to release the earnest money, and both listing and selling brokers or agents sign. All parties agree to any payment made to one another. And again, this is in essence an out-of-court settlement agreement to avoid any future lawsuits. All right, you guys. Woo! Earnest money. Again, that has been the theme of this course. And the reason is that if nothing's an issue until it's an issue. And when it's an issue, it all centers around money. Everybody wants money. Well, the pot of money that is up for grabs in a purchase and sale agreement typically is the earnest money. And the earnest money is liquidated damages for default for a seller. And there are many license laws governing you as an agent and your actions regarding the handling of earnest money. So when you tell a buyer that the earnest money is safe because you have a due diligence period and you'll get it back if you terminate within that time frame, when does the buyer think they're going to get it back? Yeah, your guys are all correct. They think they're going to get it back immediately. However, if the buyer's earnest money was a personal check, the holder may not release it until a certain time frame has passed. Remember, we talked about that they might have policies on holding a personal check, 3 banking days, 5 banking days, 10 banking days. If a seller doesn't sign the release portion of the TNR, again, even if the buyer completely terminated prior to the end of their due diligence period or prior to the expiration of a contingency period, but the seller doesn't sign the release, we can't just release it to the buyer. You have to do that 10-day letter. It's in dispute and is tied up. Either the 10-day letter or, my goodness, may have to interplead it into a court. If the buyer wants to write an offer on another house, seller number 2 is also going to want what? Yep, you got it. They're going to want earnest money themselves. Well, if the earnest money is in dispute, then it's not available for another contract. So a buyer may not get their funds back immediately. Well, first of all, if the buyer defaulted, they're not going to get their funds back. And that would be, for example, if they sent the TNR after the contingency time frame, if they terminated under financing contingency but didn't send the loan denial letter, if the loan denial letter has reasons on it that don't protect the earnest money. So there are various reasons where a buyer will default and won't get their earnest money back. If the buyer is actually entitled to the funds, the holder may not disperse, again, at least till 10 days after the date the notice is sent to the parties, if that's the route that the holder is going. And that can turn into a long time frame. It could be 1 to 5 days before the holder, it could be a couple days before you as a buyer's agent realize you're not getting back that TNR where the release part is signed by the seller. So there's 2 days. Then you have to let the holder know that you've got earnest money in dispute because the seller won't sign the release portion. Then it could take a few days after that for the holder to actually go through the contract and figure out what happened. Then after the holder sends notice, the holder can't even disperse those funds until 10 days after the date of the notice. So we could potentially be at 2 weeks or so. Or if it's really complicated or too much money, the holder can interplead into a court, and that could take months. Also, if the holder does disperse the earnest money per the 10-day letter, the holder can't automatically apply those funds to another contract. So an agent must get buyer's signature directing the holder to keep them. So let's say even if there is a TNR that's fully executed or after the 10 days and the buyer is going under contract on another house and the buyer says, look, holder, broker, just hold those. You already have those funds on deposit. Just apply them towards my next house, the contract number 2. Well, as a holder, I can't automatically do that. So an agent, you guys, you must get a buyer's signature directing the holder to keep the funds on deposit once they now belong to the buyer and apply those funds to a new contract. You need to check with your own broker. At Maximum One, we have a form called Transfer of Earnest Money that we do share with our agents to get their buyers to sign this because we need this in writing. If you are not a Maximum One agent, please check with your broker to come up with this form so that the holder can transfer those funds identified to another property. Feel free to email me if you want me to share that with you, and please run it by your broker. Also, regarding earnest money, you guys as agents, y'all need to find out the method of the holder disperses funds. So once I can disperse them to the buyer, well, how am I doing it? Am I sending him a check in the mail? Am I dispersing it to the agent, leaving it up to the agent to get it back to the buyer? Am I sending it electronically through bill pay, which takes some time? You need to find out, whomever the holder is, what their method of disbursement is. Now, in a TNR, we get this all the time. If earnest money is addressed in the creation of a contract, it must also be addressed in the termination of a contract, even if the buyer has not yet remitted the funds. Like a loan, you guys, a loan is part of a contract even though the funds are not readily available for 30 days or so. The earnest money is part of a contract even if it has not yet been remitted per the buyer. So for example, let's say you go under contract and it says buyer to remit earnest money to holder 5 days after binding agreement date, but the buyer ends up terminating on day 3. So they haven't even been required to send in the funds. Well, on the release portion, you don't put no earnest money. There was still earnest money in the deal. So in the release portion of a TNR, if the buyer has not yet remitted the funds per the contract, you simply write buyer to retain earnest money not yet remitted per paragraph A7B. And that paragraph A7B is where it says buyer to remit earnest money X number of days after binding agreement date. So you like that? Buyer to retain earnest money not yet remitted per paragraph A7B. But you must address the earnest money in the TNR. Again, both agents need to follow up with the holder. Did you receive the earnest money? Did you deposit the earnest money? And again, earnest money, we talked about this, in certified funds or a wire may be released much faster than a personal check. Also, a buyer can't stop payment on certified funds. Now, if a buyer remits funds directly to the holder, you need to make sure, like for example, if the buyer is sending in a letter to the holder with a check, you know, the earnest money, you need to make sure they include in that letter they send, what's the property address and what is the agent's name. So many times, I can't tell you, we'll get a check in the mail, an envelope payable to ABC Brokerage. We open it up, there's a check in there, and in the reference section, in the memo section, it says earnest money. And the address on the check is the buyer's current home address. We have no idea what contract that earnest money goes to. So please tell your buyers if they're sending the holder funds directly, note the property address and your name. Additionally, I mentioned this at the break, if the earnest money is over $10,000, the buyer will have to complete an IRS Form 8300 per the Homeland Security Act, unless it's wired. And that has a lot of personal information that buyers don't want to disclose. Check on the policy of the holder for the form of funds. For example, a lot of holders, if the earnest money is over $5,000, require it to be in certified funds. You need to check with the holder, whether that be a broker or the closing attorney, regarding the form they require. Again, earnest money is liquidated damages, is the only remedy for the seller, and earnest money is not required for a binding contract between a buyer and a seller. Again, you guys, it is your responsibility to follow up with the holder to check if they received the funds, because both parties, buyer and seller, have contractual rights to those funds if there's an issue. Did you mail it in? Did the buyer mail it in, deliver it, wire it? What address did some of the brokerages have multiple offices. Well, what address did the buyer send those that money into? Also, did the buyer put your name on the envelope? In that case, the staff at the brokerage may have just stuck that envelope in your mailbox there and didn't realize it was earnest money. What memo is written on the check, so forth and so on. You need to make sure that the staff at whomever the holder is knows what transaction to attribute that earnest money to. Woohoo! We made it! 12:31, yay. Thank you guys so much. Just in general, please remember, confirm all of your contract questions with your broker. We have additional classes. If you go to registerforreclasses.com and select a geographic area, you'll be directed to a smaller calendar that has all the classes. All of our classes offered through the Georgia Real Estate Academy in May are virtual. We are waiting for a few more weeks to figure out what we're going to do in June. We have to see what Governor Kemp does and kind of what's going on. I will tell you that we will continue virtual classes through the end of the year, but we may also have additional classroom classes. So just please check out the calendars for that. Again, I have a YouTube channel called Real Estate Made Crystal Clear. I have 4 years or so of real estate contract tips on there. It's not, obviously I am the broker of Maximum One Realty, so per GREC advertising laws, I have to advertise that. But this channel is really directed for all agents in Georgia regarding contract tips and issues. And I do contract tips on the GAR contract forms, the RE contract forms, the changes, as well as a variety of other issues and license law. So please feel free to check out that YouTube channel. And I believe, I hope, it is my hope that you will find it helpful to your real estate business, regardless of what broker holds your license. I am all about education and training, as well as the school, and I think you will find it useful. And everybody have a joyous and prosperous and healthy year, helping others with all of their real estate needs. You guys, there are buyers and sellers out there right now who need your help, so go help them. And especially as open up, they're going to be out there. We're still getting multiple offers on listings. So thank you guys so much. I appreciate your time. Everybody, please stay healthy, stay happy, stay helpful, and continue to be a blessing to your buying and selling public.
Dana, I have a question.
I will stay on for any questions. If you are not asking a question but want to hear, please keep yourself muted. Yes.
Dana, you said a few minutes ago that earnest money is not required.
Correct.
And I thought that you must have earnest money verbiage in every contract, but you're saying it's not. You can do a contract without earnest money.
Yeah, buyer and a seller can absolutely agree to go under contract with $0 earnest money. Remember earlier in the class, I said earnest money is kind of like layaway. You're putting
Right.
a deposit, a good faith deposit, that you're going to come to closing a few days later and close on the property. But if you don't
Right.
deposit, when you go to closing, you owe all the money. So let's say you're buying a house for $250,000. If you put in earnest money of $5,000, now I'm not talking about taxes and stuff like that.
Right.
Closing, you have to come to closing with $45,000 because there's already $5,000 on hold in the form of earnest money. If there's no earnest money in the deal, then you come to closing with all $250,000. But it's something to be negotiated between the buyer and the seller. It is not the consideration of the contract.
Good deal. Thank you so much.
Yes, ma'am. My pleasure.
Hi, Dana. Say Sue Spinsato. I have a
Hey,
question.
Jesus.
Hi. So I have a situation where I had a buy-in contract, and the house didn't appraise. So both parties didn't want to renegotiate the price. Well, the seller didn't want to renegotiate the price. So the finance contingency was due. So we extended it another day, try to review the appraisal. So again, it came back and there's still no same price. So now, how can I protect the earnest money for the buyer? I have a termination, but I don't have the unilateral one. I have the mutual one, which the seller hasn't signed yet.
Okay. So first of all, generally speaking, a financing contingency is a completely separate contingency than an appraisal contingency. In essence, a financing contingency is an assessment of the risk of the buyer paying back the lender the money. So that is an assessment or an evaluation, so to speak, of the buyer's ability to pay back the lender the money. The appraisal contingency is a risk assessment of the property. If the buyer doesn't pay me back and I get the house, the house is collateral for the loan. Am I going to be able to sell it and recoup my money by selling it? So an appraisal contingency has to do with the property. Financing contingency has to do with the buyer. So if a house doesn't appraise, you need to extend the appraisal contingency. The financing contingency has nothing to do with it. You can have a buyer completely no issues with the financing and it not appraised. Well, extending the financing contingency doesn't help you. So just generally speaking, Jesus, that's not directed to you. I get that question a lot. Those are two separate contingencies, even though they're on the same form. So what kind of loan? Is it a conventional loan, FHA loan, or VA?
Conventional.
Conventional loan. So you have to give the seller the opportunity to sell it for lower. So you did that, correct?
Well, I spoke with the agent and they're not willing to go lower, but I didn't send them an amendment to reduce the sales price.
Nope. You guys. Buyer agent communication has no bearing on the contract. That form clearly states the buyer must send the amendment to address the amendment to reduce the sale price to the seller prior to the expiration of that day. So how many, so you had an appraisal contingency for X number of days. And when does that appraisal contingency expire?
That actually expired on yesterday, Wednesday.
And the amendment, and the buyer did not send that amendment to the seller with a copy of the appraisal prior to last night at 11:59 p.m.
We did send the copy of the appraisal, but not the amendment.
Technically, if your buyer does not close on that house, your buyer's in default because your buyer did not follow what they had said they were going to follow on that conventional loan exhibit.
Okay, so even if they signed a termination of contract yesterday?
That's not the way the conventional loan exhibit works. The way the conventional loan exhibit works is it states, I mean, if you can get the, hold on, I'm going to scroll through this. If you can get the seller to agree to release the earnest money to the buyer, then you are in good shape because a buyer and a seller can agree to do anything they want regarding the earnest money. But technically, Jesus, your buyer is technically out of contract. Okay, hang on, let me show you. I'm going to share my screen and show you that exhibit. Okay, this is the conventional loan contingency exhibit. Get rid of that. Financing contingency. Okay, no, we're talking about appraisal. Appraisal contingency. In addition to the other buyer's rights, this agreement shall be subject to the appraisal. If the appraisal is for less than the buyer's purchase price, buyer shall within, and what did you have here, like 21 days?
Yeah, that's correct.
Okay, and that 21 days ended last night at 11:59 p.m.
No, it ended, I think the Friday before, but we had it extended.
Till when?
Until yesterday.
Okay, so the extension last night. So what this states is buyer shall within that number of days, and that number of days was extended by the amendment, shall have the right to request the seller to reduce the sale price to a price, not, at least the appraised price, by submitting an amendment to the sale price, F713, to the seller, along with a copy of the appraisal supporting the lower price. In the event the buyer does not timely submit that amendment to the seller, the buyer, in essence, has waived this appraisal contingency. So technically speaking, Jesus, because you sent the appraisal, but you didn't send that amendment, it clearly states the buyer has to send that amendment within that time frame. So your only hope at this case, and then after that, the seller has to respond within 3 days of when you send that. If they don't respond, then the buyer has 3 more days to terminate.
Okay.
So at this point, so technically your buyer has no more appraisal contingency. So technically your buyer is obligated to close and pay the higher price and bring cash for the difference. Technically, if your buyer terminates, your buyer will be in default because they did not meet the terms of this, okay? However, so tell me again, where are you now? You sent the amendment to the you sent the appraisal to the listing agent. And now tell me a little bit more about the termination. Who sent a termination? The buyer sent a termination?
Yeah, the buyer did, but it was the mutual one. It wasn't the unilateral one.
So really, because the buyer's in default, that really would be a good one to sign. And so what is your communication with the listing agent like now? What is the listing agent saying the seller is going to do or not do?
So I called this morning and she didn't answer by text, and I said, hey, I haven't gotten back the termination yet. She was like, well, I should have it today because the seller's in labor. She's having a baby. So, but that's what she said. And now, now I'm a little concerned about this earnest money being at risk, because I don't know if this agent is really, okay with that, and the seller's okay with it. But by the sounds of it, she's saying she should have it signed today. I'm just not confident in having that in writing yet.
Well, I would sit tight, because if you can get that, seller to sign the mutual termination and the mutual release of earnest money, you are going to be doing really well. Because right now your buyer's in default. If your buyer doesn't close, it's not terminated, because since you sent the mutual one, you need both party signatures to terminate. So you still have an active contract right now. If your buyer doesn't close, your buyer's going to be in default because your buyer did not follow those specific things outlined under the appraisal contingency. You did send the appraisal, but the buyer did not send that amendment, and that is required to go through that process. So I would just kind of sit tight right now. Your buyer's earnest money is at, when are you scheduled to close?
That was May 19th.
Okay. I just kind of sit tight right now, and hopefully you'll get that mutual termination and release signed by the seller, directing the holder to release the earnest money back to the buyer.
Now, is it too late to send that amendment to reduce the price?
I mean, you can always send it, but you're out of protection for the buyer's earnest money at this point.
Okay.
But why don't you do this? Why don't you, I would have a discussion with the listing agent and perhaps talk to the listing agent and say, hey, look, why don't I go ahead and send the amendment to reduce the price anyway? And then that way, your buyer will have the decision. Do they want to sell it for the lower price or go ahead and terminate?
Okay.
I mean, unless your listing agent is on this class, unless the listing agent's on this class. So technically, just kind of like my example to Steve earlier, and I don't know if you heard that or not. The contract is a set of instructions, just like we have laws on our books. For example, the posted speed limit sign, if you exceed that speed limit, you are breaking the law, and, nothing happens unless somebody calls you out, like a police officer that pulls you over for speeding. Well, technically, the buyer and the seller, the buyer did not follow the terms of the contract. They agreed to go with the contract. But if the seller says, you know what, that's fine, either I'm going to sell it to you for the lower price or I'm going to give you the earnest money back. If the seller agrees to that, then the seller agrees to that. The issue is if the seller does not agree to that, the buyer is in default for not following the terms of the contract. If you go faster than 65, everything could be fine. If you go faster than 65 and a police officer pulls you over and gives you a ticket, you could be obligated to pay that ticket, or you could go in front of a judge and a judge could say, no, I'm not going to make you pay that ticket, or the police officer could give you a warning. So the contract in and of itself, which was the purpose of this class, is to bring you guys aware, make you aware of what's in there. Technically, per the terms of the contract, the buyer either needs to close on that property, bring the additional money to closing, or if they don't, the buyer will be in default. However, the seller can agree to give the buyer the earnest money back if it doesn't close, or agree to sell it for a lower price.
Right. So now the seller did have another contract in place prior to ours because the lady had lost her job, but she's willing to go back to that contract since this house didn't appraise, because the first contract did appraise at the contract price above what we have. So that's my only hope, that she's okay with knowing she has a backup buyer and not go after the earnest money now.
So at this point, hopefully the seller will sign that TNR, giving the earnest money back to the buyer. If not, then you will have to let the holder of the earnest money know. Well, if not, you don't have a terminated contract. You're still in contract through May 19th. But at some point, if it doesn't close, you will have to, either the buyer would have to send over a unilateral termination, or on May 20th, when it doesn't close, if the buyer chooses not to close, you'll have to let the holder of the earnest money know that the contract didn't close and the seller and buyer did not agree in writing what happens to that earnest money. And then the holder will have to do that 10-day letter.
Okay. So now if these buyers are interested in another property, they would need to do a whole new set of earnest money funds, or can?
Yeah, this earnest money is tied up. The seller hasn't agreed to, well, right now you don't have a terminated contract on this contract because the mutual, it's not terminated until both buyer and seller sign it. If the buyer does want to terminate, you'd have to send the unilateral. And if the seller doesn't agree to give the buyer back the earnest money, these funds are tied up. So if the buyer, and right now from how you've described it, it's kind of hard to answer without actually looking at the contract, but how you've described it, these funds are tied up and not available to use on another contract. Okay, can the buyer hold the agent liable for not presenting the amendment in time? Nope, that's what that Sergeant Schultz paragraph was about, disclaimers, so forth and so on. The buyer also signs the contract, and the buyer also reads that it is the buyer's responsibility to send that amendment to the sale price. So you guys, these GAR contracts, GAR, Georgia Association of Realtors, these contracts are designed to protect you, the agent, and your brokers. So, you know, can a buyer make a case of liability against the agent? Perhaps, but remember the extent of liability. Remember that liability clause we covered? Since there's no commission paid, the maximum amount of liability is what? Remember? $100. You guys, seriously, these GAR contracts are really designed to protect you. Hey, Jesus, you're getting a bunch of people wishing you luck.
I need it right about now because I feel terrible. Just wasn't paying attention.
Well, you know what? Like I said, what you might want to do is it sounds like you have a pretty good relationship with the listing agent, and it sounds like the seller does have some additional recourse, and she's having a baby. So hopefully they're excited about their new wonderful blessing that will be joining us shortly. So you might want to send over that amendment to the sale price and say, hey, look, you know, I know there's a lot going on with your seller. I'm not sure what they want to do. So, you know, there's a couple of options. Either they can agree to sell it for the lower price and be done and move on with their new life and their new home and their new baby. Or, you know, let's just go ahead and get them to either sign the amendment or get them to sign the termination. So just kind of present it to the listing agent that way and see what happens. It's up to the listing agent to protect the seller and understand the contract from the seller's perspective. Right now, you're asking me questions from the buyer's perspective, and that's from the buyer's perspective, kind of how I would approach it.
All right, I appreciate that. That helps me a lot.
Good luck.
Thank you.
All right, that was a question about that. Can the buyer hold the agent liable?
Hey, Dana.
Yeah.
It's me. Hey, on that same vein, like, I totally get that they would be responsible for earnest money, but like, what if, I mean, of course it would have to, I mean, what if they just don't have the money to close, even though they are responsible?
Then they're not going to be able to close, and they'll default on
know.
the contract by not showing up closing.
So basically they're only really out their earnest money at worst case scenario, unless they go through the courts, right?
Well, even if they go through the courts, you can't, the buyer and the seller agree that the only remedy for default is earnest money. So a judge is going to take the earnest money. Yeah.
So that's their worst case scenario, really.
Right. Now, a
Right.
judge, no, I say that, and a judge can always overturn anything in a contract, but the contract gives the basis for the attorneys to make the argument. Look, you agreed that this was the sole remedy.
Right. Exactly. Good luck, Jesus.
Any other questions? Did you guys, I know, like I said, I've got a lot of experienced agents as well as new agents or agents getting into it. But even for all the experienced agents, I hope this was a good, thorough explanation of everything going on. Again, I do have a video coming out on that YouTube channel about all of the changes that came out in GAR May 1st. The two biggest ones were the ones I presented, the sale release contingency exhibit, the exhibit to the with the closing attorney holding earnest money. There's a lead-based paint change. I've got the video recorded. When I edited it, it had problems. The voice was off, so I'm going to work on that this afternoon.
Hey, Dana, I have one question.
Okay.
So I've had a situation, this is Jay, and come to find out, apparently the only recourse the seller has to get out of a contract beyond the earnest is not agreeing to the amendment to address concerns in the event that there are repairs that the buyer is asking for. Are there any other instances where sellers are able to back out of an agreement, and what if they just change their mind?
Okay, so first of all, a seller cannot terminate under due diligence. A due diligence period is only a buyer option to terminate. So I don't understand what your first part of that question
Well,
is.
okay, well, and that's correct. And so after speaking with other brokers, though, they did say, well, the only way that ultimately you could move forward, that doesn't give the seller an out. But if there are repairs that the buyer's like, well, listen, I'm just not going to move forward with this contract because I don't want to incur these damages or these issues with the property. So beyond that, there's no other recourse a seller has to get out of a contract. Huh?
Well, a seller can't get out of the contract for that. If a buyer, the seller doesn't have to agree to repairs, but it's a buyer's option to terminate or not. If the buyer stays in it, the buyer stays in it, and the seller's not obligated to do repairs if they didn't agree to any on an amendment. But if a buyer presents an amendment to a seller to address concerns with the property and the seller doesn't want to do them, the seller can't terminate. They just don't do the repairs. So other than that, yes, there are several seller termination rights. Well, not several. There are seller termination rights in the contract. One of them was, we talked about earnest money. If the buyer doesn't remit the earnest money within the time frame, or the money is no good, the holder gets an NSF notice from the bank. The holder sends notice to the buyer and the seller stating the buyer's in default for not remitting the earnest money. The buyer then has 3 banking days to cure the default. If the buyer does not cure the default, the seller then has 7 days after that to terminate the contract. If the seller does not terminate the contract, then the seller agrees to go through with the contract. There's just no earnest money in the deal. So that's one seller termination right. There is a, I'm trying to think, there are a few of them throughout, but they are specific. There aren't a whole lot, but they are specifically spelled out. And again, the GAR contract specifically talks about if a party is in default, there's notice of the default, a time frame to cure, and then the party that was not in default has a time frame to terminate. Oh, here's another one, the financing contingency we went through. After the financing contingency time frame has passed and the buyer didn't terminate, then the seller has the right to request evidence of buyer's ability to close. The buyer has to provide that documentation within 7 days. If the buyer doesn't, the seller sends notice, hey, I never got your evidence of your ability to close. Buyer has 3 days to cure. If the buyer doesn't cure, then the seller has 7 days thereafter where the seller can terminate. We talked about that the time frames kind of get a little wonky, but there's another seller termination right prescribed in the contract.
So in that regard, then, let's just say if the finance contingency was won, if they don't yet have that, let's just say clear to close within that 3 days of the finance contingency expiration, would that be another reason?
Well, again, remember what I said about the contracts, they're instructions. It's not clear to close. So let me share my screen again.
Still have until the closing date even.
So let me show you guys. All right. All right, so this is the financing contingency exhibit, okay? Right of the seller to request evidence. Now, this is not clear to close. There can still be conditions. This is a loan commitment letter with conditions. Right of seller to request evidence of buyer's ability to close. If the financing contingency ends, so let's say we had a 21-day financing contingency, we're on day 22. The buyer didn't terminate, so we're still in contract with the buyer. The seller has the right, but not the obligation, to request the buyer to provide written evidence of the buyer's financial ability to purchase the property. A copy of a loan commitment letter from each institutional mortgage from whom they are seeking a mortgage, stating the type, amount, and terms of the loan and conditions for funding the loan. So this is a loan commitment letter with conditions. For example, final verification of employment, final credit check, so forth and so on. This is not a clear to close. This is a loan commitment letter with conditions, shall be deemed sufficient evidence. Now, this evidence doesn't mean, it's not a guarantee that it's going to close, but the seller has the right to request this commitment letter from the lender. Once the seller sends notice to the buyer saying, hey, you didn't terminate, so I want your evidence of your ability to close. The buyer then has 7 days from the date the seller delivers notice of the buyer requesting evidence to produce it. Now, seller's right to terminate. In the event the buyer doesn't provide the seller with this loan commitment letter within the time frame, those 7 days after receiving the request, then the seller, so the seller says, okay, buyer, you never sent that to me. The seller again is then obligated again to send notice to the buyer saying, now you're in default and you now have 3 more days from the date of this notice to send me this loan commitment letter. So we've sent a notice, a request. We've got 7 days. We didn't get it. So on day 8, the seller sends an additional notice saying you're now in default. You now have 3 days. So that would be day 9, day 10, day 11. If we still don't get it on day 12, so the buyer does not timely cure the default, then the seller has 7 days. So day 12, 13, 14, 15, 16, 17, 18. Through day 18 to terminate. If the seller does not terminate within that time frame, then the seller loses the right to terminate and you go on with the contract.
That's a way. Okay.
Yeah, so the seller termination rights are spelled out. There are not a lot, but they are there and they are spelled out in the purchase and sale agreement and the various exhibits.
Yeah, just limited. So really sellers just can't change their mind and like, you know what, listen, this is my family house. I thought we wanted to sell, but we don't.
So if they do, the seller would default on, I mean, you can't force, I mean, the seller would default on the contract and then the buyer either terminates and gets the earnest money back and goes and finds another house, or the buyer has the option to sue the seller for specific performance and a judge would say, no, seller, you got to sell to this buyer and honor that contract.
Yeah, specific performance. That's okay. Thank you, Dana.
You're welcome. All right, anybody else? All right. Well, thank you guys so much. I appreciate everything. And again, I do refer you to your own brokers for any contract questions or closing attorneys. And I just want to thank you guys so much for your time. Everybody out there still needs your help. Everybody stay happy, stay healthy, continue to remain a blessing to your buying and selling public. And see you next time. Thank you guys so much. Bye-bye.